And Council, I was just discussing with court security, because of the number of inmates we've transported today, we're going to have to accommodate detention and call the inmates in the order that they were transported. I apologize that we can't call you in the order that you signed up on the list.
First up is Brian Wiley.
Good morning, Your Honor.
W-I-L-E-Y.
Good morning.
Brandy Merrifield on behalf of Brian Wiley. You'll find it listed under Flaherty. Both of my cases are today in 24 CF 2458.
Yes, ma'am.
We'd like to leave Mr. Wiley set for docket day as a plea or continue. We do have kind of the underworkings of an agreement. We just need to refine some terms.
All right. And did you resolve the issues with the depots that you had from last time where you had the no-shows and that's been squared away?
I did judge based on some of that and some of the content from the depots is how we were able to come to the workings of an agreement. So I think we are prepared.
All right, very good. We'll see you on docket day then.
Thank you.
All right.
The next one that looks to be queued up, Judge, is Brandy Merrifield on behalf of Fernando Medina in 24 CF 2462. In a similar situation, Judge, with Mr. Medina, we do believe that we're going to have an agreement, so we'd like to set him for docket day as plea or continue.
No objection.
All right. We'll see you on docket day. Thank you.
Thank you, Judge. That's all I have this morning.
Thank you, Ms. Merrifield. Good day.
Your Honor, next will be Roderick Bryant.
Bryant.
Roderick Bryant, B-R-Y-A-N-T.
Mr. Cobb. Oh, hold on just a second. He's available remotely. I apologize. Just a second.
Judge, he just walked in.
Oh.
Good morning, Judge.
Good morning, Mr. Cobb.
Judge, I wrote Miss Natalie a note telling her I was out in the car doing Zoom court for the pendency docket. I don't know if you got that, but that's why I wasn't here right when I caught.
Yes, sir. I was confused by the note. I thought you were available remotely. Now I understand what that note means.
Okay.
Go ahead, sir.
This is State of Florida versus Roderick Bryant. As you know, Mr. Bryant's filed a motion requesting a Nelson hearing alleging ineffective assistance of counsel. Prior to that, he filed a bar complaint against me. The bar dismissed the complaint, but in the course of the bar complaint, he made several accusations against me. I've discussed with the bar about filing a motion to withdraw, but I've hesitated filing a motion to withdraw because I didn't want it to appear that I filed a motion to withdraw because he filed his motion for a Nelson hearing. I don't think that gives a good impression to the court, but the bar complaint came first. Then when the bar complaint got dismissed, the motion for a Nelson hearing came second. If Mr. Bryant wants a new attorney, he can address that with the court, but he needs to understand if he wants a new attorney is going to have to get appointed and go through his cases and do all the stuff I've already done to try to get ready. So I don't know how the court wants to address it. I do feel like I have grounds to withdraw, but I would fight through those grounds and continue to represent him if it meant trying to help Mr. Bryant, but I don't think he wants me to be his attorney at all.
All right. Mr. Bryant, do you feel like your relationship with Mr. Cobb is such that he can no longer represent you? Is that what you feel?
Yes, sir.
And that's, you feel your relationship is tenuous, Mr. Cobb, with Mr. Bryant, based
Yes,
upon
it's
what's...
stated, yes, there is due to the bar complaint and some things that were said, yeah, it is tenuous, Judge. But, you know,
And if you go forward, you'd be concerned that that might result in some other consequences for you and for your client.
yes, sir. I do.
All right. And so, do you wish to withdraw based upon those circumstances?
I would like to withdraw based on the bar complaint and the tenuous relationship that we have currently. I believe it can.
Is that what your desire, Mr. Bryant?
Yes, sir.
Okay. Now, you realize, if I appoint new counsel, the way that your new counsel is going to have to go through all of this stuff again, and this case is pretty old, right?
Yes, sir.
And so it's going to take some time for them to get up to speed.
I understand.
All right? All right, so I'll grant your oral motion to withdraw.
And I'll sign, for the new counsel, whoever's appointed, I'll sign the waiver of fees for the JAC, and I'll present an order to the court to execute later on.
All right, and who would be next on the list, ma'am?
Has Mr. Nutt represented you before? Okay.
Mr. Nupps is appointed. Now, what I'm going to do is I'm going to leave this on for docket day, just so you'll be back on the docket and you'll have a chance for, is Mr. Nupps here yet today? I know he indicated he'd be here a little later, so I'll leave it on for docket day, so you'll have a chance to see Mr. Nopes if he can't get to you between now and docket day, because he's got quite a few cases, all right?
Yes, sir.
Okay. All right, thank you now.
Next will be Emmanuel Ocala, C-O-L-L-E-Y.
Judge, can I approach for a second?
Granted.
Is Mr. Colley in? Okay. Judge, this is State of Florida versus Emmanuel Colley in two cases, 2019 2948C and 2024 1008. I spoke with Mr. Colley at the jail yesterday, and I spoke with Mr. Alderman. Earlier last week, we got some amended discovery that the state sent me involving a witness, a new witness that I wasn't aware about, a proffer that that witness made along with a CD and a video. So I told Mr. Colley I would need to definitely depose that witness. The status of the case is I've got all the discovery from the state other than what just came in. I've had it. I finally got copies of all of the depositions, including one that was missing. So the case is in a position where we could go to trial next cycle, as long as I'm able to depose this new witness that the state told me about. So I'm going to be asking for a continuance so that I can do that. But I believe after this, the case will be in a position where we can resolve it, try it.
State?
So I got an email from Mr. Alderman, and he does not have an objection to the continuance.
All right. And with the understanding based, and that's as to the 19 case that we're talking about, right?
Yes, sir, the murder case.
All right.
2948.
All right, and so the discovery issues have been an ongoing problem, but you believe now, based upon this most recent disclosure, that you have everything that you need, And you've received, my notes indicate that you knew about the depot, but it was missing, and now you've received that.
Yes, sir.
And you've got all the information on the hard drive that was previously, and now with this last witness, if you have that depot, you'll be done.
Yes, sir.
And you'll be ready next cycle,
Yes, sir.
okay? All right, all right, it'll be continued to 7/14.
Thank you, Judge.
Next person will be Luna.
Say again?
Luna.
Luna? Isaiah Luna?
Judge, State of Florida versus Isaiah Luna, 2022 CF 1145. I believe the co-defendants' cases have already been continued to the July docket, and here's the reason why. 2 weeks ago, we received an amended discovery exhibit that listed probably 5 proffers, several from some co-defendants, and then we also received a bunch of phone downloads from the state that have been recorded, jail calls that have been recorded. The investigator that I have working on this case is going through all that with me, but because of the new proffers, those people that made the proffers have basically, indicated, hey, I'm making a proffer, I'm a witness, therefore they need to be deposed. And so I believe the cases have already been continued with the co-defendants so we can schedule depositions. So I'm asking for continuance to the July 14th date.
State?
There's no objection from the state, Your Honor.
Is that consistent with the co-defendants' dispositions?
Yes, Your Honor.
Okay. And and with that, are y'all going to work together to get those additional depositions taken so we're not?
Absolutely.
all right.
Yeah, Mr. Griffith has been taking the lead on scheduling the combined depositions, and his office is going to take the lead and do that so that we can get these witnesses deposed.
All right, very good.
Next one is Eric McQueen.
Judge, State of Florida versus Eric McQueen, 2023 CF 2097. Mr. Gomez and I have been working diligently on trying to resolve this case. There was some movement late yesterday with plea offers, and because I was coming back from court, I didn't have time to really fully discuss that with Mr. McQueen, but I'm asking that it be set on Monday's docket for plea or trial. I think we'll be able to resolve it, but if we can't, we're going to have to try it. Correct, Mr. Gomez?
That's correct, Your Honor.
What is the offer at this time, so the court is aware of what it is and
The offer-
Mr. McQueen can hear it here in open court?
As
Mr.
of right now,
Gomez.
Your Honor, it's a plea to the guideline sentence, and that's 51.9 months in the Department of Corrections.
All right, and his exposure would be a lot more than that, as he's charged with burglary of a dwelling with an assault or battery. And I need to discuss that, go over those ramifications with Mr. McQueen in detail, but I believe we can resolve it on Monday, but if not, we will have to try the case.
Okay, if the case is tried, how much time reasonably do you think it'll be necessary to try the case?
1 day, Your Honor.
Do you agree, Mr. Cobb?
I agree, we could do it one day.
And how many jurors do you think we'll need?
The
I would say
panel-
maybe around 40 to 45, given some of the charges, just might be a little bit more emotionally charged, I guess.
All right, so 45 jurors. Is there any special scheduling we need to be concerned about in setting it for trial?
I don't
2
believe
weeks.
so. All my witnesses are local, Your Honor, so I think it'd be fairly easy. I've been in contact with the victim very regularly, so I think it would be very easy for us, that we won't have any scheduling issues.
All right, very good. All right, we'll see you on docket day.
Next is Leo Nix.
Judge, before Mr. Nix, oh, sorry. Yeah, I was gonna ask if we could do Morris really quick.
Tyvon Morris, being told that he is in another institution.
Yeah, that's State of Florida versus Tavion Morris, 2022 CF 1809. He is in the Escambia County Jail. Mr. Morris and I have been in contact. I've told him the status of the case, which I'm going to relate to the court now. The co-defendant, Nathaniel Riggs' case, I believe may have already been continued. I may be mistaken, but we have depositions of the final witnesses scheduled later this month, I believe, or in June.
We do, and there was one proffered witness that was listed in discovery, and I believe this deposition needs to be taken, and then after that, we'll be ready for trial.
Right. I got a lot of proffers last week, so.
And so you have the witness that you've got scheduled in June, and you have another proffer witness that you need to schedule, is that correct?
Yes, sir.
And, you know, these are the last two remaining witnesses, including the proffer. I believe we have to take the deposition of the medical examiner and one other law enforcement officer, and then the new witness that was mentioned in the proffer. And that'll be it. It'll be tied up and ready to go. All the discovery is complete. I have everything I need. And this would be one of those cases that we could definitely try at the next cycle.
All right, it'll be continued then.
To the 7/24 date?
7/14.
7/14, thank you,
And
Judge.
Mr. Carver, are you standing in for Mr. Riggs'
I am.
counsel still today?
Well, and so if you'd approach on that.
I don't think it's on.
All right.
No, because it's, see, I'm in charge.
All right, so now let's focus on who we have in front of us now.
Yeah, State of Florida versus Leo Nix. Do you want me to run through all the cases, or is it sufficient?
I have them right here.
All right, thank you, Judge. Mr. Gomez and I, we've been working to resolve the case. We had some late movement again last night. I did get the FDLE report sent to me earlier this week, which I had not had, but I don't think it's going to be an impediment to resolving it. But I do need to go over the plea offer with Mr. Nix, and so it has to be left on the docket for Monday.
All right, and what is the current plea offer, Mr. Gomez?
As of right now, Your Honor, the most recent one that we had given as of like, was it 10 o'clock last night?
Last night. So see, we're trying, Judge.
Hold on, let me see.
I believe it was 13-something, 13.25, or it was lowest permissible sentence, but
Guideline sentence?
It was a guideline sentence. I had offered to dismiss the grand theft of a firearm on both charges. Or he has a lot, but on two of the charges I offered to dismiss the grand theft of a firearm. In doing so, that would bring the lowest permissible sentence down to 135.6 months in the Department of Corrections, which is, I believe, around 11 and some change years, if I'm not mistaken. We are looking into a couple of things in terms of offers, but that's right now is currently the offer that's outstanding, Your Honor.
All right, and so without the dismissal, what would the sentence, the guideline sentence be?
it's like 200 years almost.
176.1 months in the Department of Corrections.
Well, the max, if you get,
The max is a lot.
yes. It says, I think it said 200 years when I read it, but, you know, that's like several lifetimes. But this is needless to say, that he'd be exposed to a lot more than the 135 months.
Right. So I'm going to get, without the dismissal, the minimum guidelines is 176. With the dismissal, the guideline is 135, and the state's present offer is a guideline of 135 with the dismissal.
Correct, Your Honor. And the maximum sentence with the dismissal is 191.7 years in the Department of Corrections.
Okay. All right. And so docket day for plea or continue, is that what we're saying?
Yes, sir.
Okay. All right, very good. See you on docket day. Thank you, Mr. Nix.
Next is James Prelwitz.
Judge, prior to Mr. Prowitz, there's a case on the docket, Quentin Powell. He's currently in the Santa Rosa County Jail. I don't think he's not brought over. But I'd like to handle that. If I could approach with Mr. Gomez, I could explain what's going on with that.
All right, yes, sir.
Prelwitz.
Yeah, he told me he wasn't going to get on the bus. Yeah. When I went to meet with him in the jail, he told me that's what was going to happen. Sorry,
Okay,
I
we'll
should've
leave
told
that set for docket day.
you. Thank you, Judge. Judge, he may not want to get on the bus docket day either, so, but we'll see what happens. That's just what he told me. Because I was going to ask for a continuance, he says, well, it's going to be continued, I'm not getting on the bus.
Okay,
So,
all right, well, let's focus on Mr. Riccio.
yes, sir. Judge, this is State of Florida versus Mr. Riccio, and Mr. Snell and I have been talking about possible plea scenarios. He had originally talked to me about doing the drug court. I went to visit Mr. Riccio in jail, and we came up with a possible alternative to that. I need to run that by Mr. Snell. This is a newer case for me, but I'm going to ask it be left on the docket for Monday, because I think we can resolve it Monday.
So plea or continue for
Yes, sir.
docket day? Is that right? Mr. Snow?
That's be fine, no objection.
All right, and so y'all chat about this alternative? Is that,
Yes, sir.
or is the state open to that, Mr. Snow?
We're gonna. That's what we're trying to. There's a way we can work this out, yes, sir.
Okay, all right, very good. See you Monday. Thank you.
Thanks.
Next one is Kevin Rogers.
Judge, this is State of Florida versus Stephen Rogers, 2023 CF 1804. Judge, a plea offer has been made to Mr. Rogers to plead to a lesser included burglary of a structure and the grand theft The offer is guidelines, lowest permissible sentence of 22.14 months or 21.2 something months. The entire time I've been representing Mr. Rogers, I told him I thought I could eventually resolve it with a plea to burglary of the structure with some time served so he wouldn't face any more exposure or an HFO filing by the state. I went down to the jail to speak with Mr. Rogers about this. He wanted me to counter the state, saying he would take the 22 months, but he wanted it to be a plea to trespass of a construction site. The state said absolutely not. We'll do the burglary of a structure. So the current offer is burglary of a structure plus the grand theft, 22 months. I believe.
22.43 months, and that would run concurrent with his sentence in the other cases, Your Honor.
Right, and he's got that amount basically for time served, so he wouldn't have any more exposure. Mr. Rogers informed me that he's not going to take the burglary of a structure charge anymore. I am going to go down to the jail and talk to him about some other issues, but right now it looks like he wants to try it. So if he wants to try it, I'll try it too.
All right, and so,
And, you know, if Mr. Gomez does file the HFO status, of course, anything he got would be doubled. Oh, Mr. Rogers asked me if he can have some time to think about it. Can I pass him to the end of the docket and let him think about it?
yes, sir, because I'm just looking, as currently charged, he's currently charged with burglary of an unoccupied dwelling, which is a second-degree felony, plus the grand theft, which is a third-degree felony, right?
Correct,
sir.
Your Honor, and if we went to trial, those would be the charges we would go on.
And so, as charged, what's his score sheet?
48.53 months is the lowest permissible sentence, Your Honor.
Okay. So a score of 48.5.
Yes, Your Honor.
And the current offer at 22.4, just looking at the progress docket, he should be, because it looks like,
Is that rank consecutive coterminous?
It'd be run concurrent with your other case, so you wouldn't get a 3-year sentence. You've got that on the BOP. This would be the 22 months credit for time served.
And that won't take away from my 22 months from my 36 months.
No, you still get credit for that towards your 3 years too.
so it kind of looks like he'd have close to that time, right?
That's correct.
Yes, sir, and that's why I negotiated so hard for this plea, is to help him avoid any possible exposure.
Let's run it.
He said, let's run it.
Let's-
I'd like to pass him to the docket. I'll write it up. I'll go back there and talk to him, and we can do it, okay? If that's
All
all
right, so just pass it to the end of the docket?
Yes, sir.
All right, so as soon as Mr. Cobb is finished with his part of the docket, if you leave Mr. Rogers to go in the interview room so that he can chat with him. Okay?
Thank you.
Next one is Peter Rybicki, R-Y-B-I-C-K-O-I.
Judge, this is State of Florida versus Peter Rybicki. He has 2 older cases, 24. They're sort of new for me, but the newest case is the 2513 case. This is the most serious case. It's the burglary PBL. We have depositions in that case scheduled for June 17th. I spoke to Mr. Rybicki at the jail. I told him we had depositions in June. I told him I was going to be asking for a continuance. He understood that, so I'm asking that the case be continued to the July date so I can have the depositions in June.
State?
No objection.
All right, it'll be continued.
Next is Antonio Swing.
Judge, this is State of Florida versus Antonio Swain. You have the case numbers there, so I'll forego that. Mr. Snell and I are working out a plea agreement, trying to resolve it, but Judge, if we can't resolve it, I believe at the last pretrial docket, you said no more continuances, so it would sit on Monday's docket for plea or trial.
And what is the present offer?
Well, the present offer from the state, I believe, was 7 years, but Mr. Snell and I have been talking about something less than that. We're going to get up and discuss it, but the last offer from the state was 7 years.
And is that a guideline sentence? What, Mr. Snell, so it's a guideline sentence?
Yes, sir.
Okay. All right, so docket day, plea or trial. If the case is tried, how much time would it take to try the case?
We just do the trafficking case, correct? Yeah, probably a day, well, a day to pick and a day to try, I
Okay.
believe.
So you say we're going to try the trafficking case. Which case is that for the
Okay, that's the
record?
2022 1589 case.
And so you think it'll take a day?
Maybe a really long, full day, but
And
yes, sir.
any need for a special number of jurors?
Just a standard amount, it's just a drug case.
All right. And any scheduling issues we need to deal with?
I don't believe so, Judge.
I'm not aware of any at this point.
Okay. All right, so plea or trial on docket day, it's either a disposition or not,
Yes, sir.
or a trial. Okay. All right, very good. Thank you.
Next is Eileen Jakes, Y-E-P-E-C.
Yepes.
Yes, sir. I can hear it.
Judge, this is Ms. Yepes, present before the court. She has two cases. This is a case that we're going to be able to resolve on Monday with a plea. Or let's ask for it to be a plea or continuance. But I need to call Bridgeway and verify some information that Ms. Yepes talked to me about, and then get up with Mr. Snell and get it written down. There was some late movement with regards to the plea negotiations, but I need time to go to the jail and
Okay.
show her the plea form and do it. So
Well,
Monday.
if you would approach, please.
Till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Judge, and thanks for reminding me last time. We announced that there'd be only one more continuance, so I'd like to leave it on the docket for plea or trial.
All right.
We're going to resolve it Monday, or we're going to go to trial. Okay? Yeah, I got something to show you. Right. It's all right. It's not the best thing in the world. I'm going to show you. That motion, just stuff.
All right, so we'll see you on docket day.
Yes, sir. All right, Judge, real quick before I go talk to Mr. Rogers, can I approach and ask a question?
Yes, sir.
This is Morgan, Jason Morgan.
Morgan?
Good morning, Your Honor. Kim Skavasky on behalf of Mr. Morgan.
Good morning, Mr. Skavasky.
Mr. Morgan, Your Honor, is set for Veterans Court tomorrow. I've spoken with both Mr. Snell and Mr. Gomez, and it's highly anticipated he's going to be entering on that date, or at least will finalize that entry. So can I have just a moment to speak with my client?
Yes, absolutely.
Thank you, Judge.
So he'll be observing tomorrow, and we anticipate he'll enter, and so we'll just leave it on for status on docket day, Monday. And if he's entered, then it'll just roll off the docket. Otherwise, we'll discuss it then.
Yes, sir. He's been set for observation. I talked with Mr. Snell today, and we believe that he'll be able to get entered into the program tomorrow as well, or hopefully. So we'll address that with Judge Mason tomorrow.
Okay. And once again, if he's entered into, simply let Ms. Natali know and Madam Clerk, and we'll take it off. Otherwise, we'll just set it for status on Monday.
Appreciate it.
Okay? All right, thank you.
Next is C. McClendon.
McClendon.
Your Honor, this is Azzy McClendon in 25 CF 330.
Good morning, Ms. Desmond.
Good morning, Your Honor. We recently got discovery on this. I would ask for continuance to the next pretrial.
No objection from the state, Your Honor.
All right, and is there anything else that you think you need, Ms.?
I haven't had a chance to review the discovery. I just got it a couple days ago.
Okay. All right, it'll be continued. Thank you very much.
Next one is Keon Purnell.
Your Honor, this is Keon Purnell in 24 CF 164. Your Honor, I asked to leave him set for docket day. I've been talking to the state about trying to get this case resolved. So I will leave him set, if we can leave him set PRC so we can see if we can resolve this one.
All right, is there a current offer?
There is, Your Honor, this is gonna be resolved on Monday. I just need to speak with my supervision about how we wanna handle it.
Okay, so clear continue on docket day?
Correct, Your
Yes,
Honor,
sir.
but we anticipate it'll be resolved on Monday.
Okay, so and this is the 164 case, right?
Yes, sir. He does
Correct.
have another case with Mr. Notes, I
Mr.
believe.
Notes. I don't see Mr. Notes yet. He's not on. All right, and we'll need to hold Mr. Purnell for Mr. Nopes as well, okay?
This will be the Rudolph.
And we got Nariah Rudolph in 25 CF 293, 19 CF 1473, 19 CF 2646. Yeah, this is the first pretrial up. I would ask to leave it for docket day just for PRC. I have sent an email to the state to see if we can try to get these worked out. If not, we'll continue it on that day.
All right, has state made an offer yet?
They did have an initial offer, but based on the constructive possession issues on the one case, I have asked them to look at the case.
Okay, all right. State?
That's, we have no objection to that.
All right, all right, very good. See you on Monday.
Next will be Dion Wingate.
This is Dion Wingate Jr. in 24 CF 62, 24 CF 419. And he has Mr. McKinney represent him in 24 CF 485. Your Honor, we do have a plea agreement and a score sheet if I may approach.
Granted. And you're just on the 62 case, right?
62 and the 419.
And then Mr. McKinney's on the 485, right?
Correct.
Right. All right, go ahead.
Your Honor, Mr. Wingate would enter a plea as charged in 24 CF 62. 24 CF 419 will be dismissed. And in 24 CF 485,
Judge, that would be pled to, Madam Clerk, that's in, part of the lesser included offense of 800.32B, which is felony indecent exposure. That's going to be the adjudication of guilt, $515 in court costs, $150 property credit. That's going to be a concurrent 5-year Department of Corrections sentence of credit for time served, concurrent between all of the other cases and counts. All the costs will be reduced to the record.
and in 25 CF 62, it'll be adjudication of guilt. On count 1, it'll be 77.7 months DOC with a 3-year minimum mandatory, credit for time served. On count 2, it'll be 7 years DOC, minimum mandatory with credit for time served. Counts 3 and 4 will be 77.7 months DOC with credit for time served. Count 5 would be 5 years DOC with credit for time served. And count 6 and 7 will be time served. Court costs will be $1,040, $50,000 fine in counts 1 and 2, all costs of judgment and reserve on any restitution.
So that's 50,000 times 2.
Yes, sir.
And then we have the surcharge, correct, on top of that, Madam Clerk, and that's, what's the surcharge?
So if there's 2 trafficking charges, it's imposed each.
Right,
I think it's 50,000 each.
correct. And then there's a surcharge on each of those, right?
Yeah, 2,500 each.
All right, Mr. Wingate, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down and move on over in front of that microphone so we speak up so we can make a good record of what you have to say. Now, there's a lot going on. You got Ms. Dudley, and you also have Mr. McKinney representing you in these cases. Is that right?
Yes, sir.
All right. How old are you?
30 years old.
And how much schooling do you have?
Up to the 10th grade.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what was announced just now by Ms. Dudley and Mr. McKinney, what you read in the plea form.
Yes, sir.
Do you understand by this plea that you're pleading no contest to the announced charges?
Yes, sir.
And by pleading no contest, what I understand you to say to me is that you believe the state has the evidence necessary to prove your guilt to the jury, and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove that to the jury beyond a reasonable doubt?
Yes, sir.
In this case, you're going to be adjudicated guilty, and there's several different sentences being imposed, and some of them overlap, and some of them have different mandatory minimum sentences, but essentially, it's 77.7 months in the Department of Corrections with the mandatory 3 years, and then another one has the 77.7 months then another one has a 7 years DOC minimum mandatory with credit for time served. And then you have the other sentence with the 77.7 which doesn't have a minimum mandatory, and then the 5 years with credit for time served, and then the other counts with time served. So the reason I'm taking time to explain all that is with the different sentences you have and the different minimum mandatories, when you figure out what your end of sentence date's going to be, there's going to be some overlaps about what those times are and when they expire.
Yes, sir.
Okay? And so if you've got questions about that, that's what they're for, to explain that. Okay? And because of the way you're being sentenced, it will clearly be confusing when you first get it on what those dates are and how that works. But essentially, it's the 77.7 is the total sentence with different mandatory times that will expire on those different sentences. Does that make sense?
Yes, sir.
Okay. Now, with that, have your lawyers taken the time to answer all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how they've represented you in this case?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. Thank you.
No, that's in all cases and counts one concurrent.
Yes, all cases and counts do run concurrent.
The judge, be absolutely redundant, that is no credit for time served.
Absolutely redundantly, credit time served.
Yes, sir. I believe that's all I have, Your Honor.
Yes, ma'am.
Thank you.
Thank you. Thank you, Mr. McKinney, for y'all working hard to resolve those.
Next will be Brad McGahee, MCG, HEE.
Mr. Gates.
Hello.
Good morning, Judge.
Good morning, Mr. Gates.
Your Honor, before the court is Brad McGehee. It's case number 24 CF 2862. May I approach?
Granted.
Mr. Gomez is obtaining the score sheet, Your Honor.
Any score sheet objections, Mr. Gates?
Based on the plea, no, sir.
All right. You may proceed by announcing the terms and conditions.
Thank you. Your Honor, Mr. McGehee is charged in a one-count information with aggravated battery. The terms of the plea and sentencing agreement are as follows. Adjudication would be withheld. It would be 7 years probation. Cost of supervision would be waived. Mr. McGehee would continue the present counseling that he's undergoing until released by the provider. No contact with the victim except through legal proceedings. The court costs of $867. And this is as a result of an uncoerced, legitimate plea bargain.
This is a downward departure, Your Honor.
All right. All right. Mr. McGehee, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Gates said on your behalf and you signed the written plea form.
I did, yes, sir.
How old are you?
How?
How old are you?
52, sir.
And how much schooling do you have?
College education, degree in finance.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in this form, what Mr. Gates just announced to me.
Yes, sir, that's correct.
Do you understand that you're pleading no contest to these charges?
I do, I understand.
And that says to me you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by making this plea you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, adjudication will be withheld. You're going to be on 7 years of probation with some fees, costs, and other conditions, including continuing your present counseling and issues regarding substances and counseling regarding that, and no contact with the victim except through legal process.
I understand, yes,
In
sir.
addition to the standard terms and conditions of probation which are recited in the plea agreement.
Yes, sir.
All right, Mr. Gates answered all your questions about the plea and how it affects you.
Yes, he did.
And are you satisfied with how Mr. Gates has represented you?
I am, yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Judge.
Now, before you leave, they're going to pass you a notice about how you need to report to probation when you're released from jail, okay? So you need to do that when you get out, all right?
Yes, sir.
All right, thank you now.
Thank you.
Thank you.
Next one is Trevor Brown.
Good morning, Mr. Griffith.
Good morning, Judge. I represent Mr. Brown. We filed a,
And Mr. Nopes, don't you have a case, did I see Mr. Nopes? Okay. Let's get Mr. Nopes in here, because doesn't he represent you as well, Mr. Brown, on
Yes,
another
sir.
case? Okay. Go ahead with your case, Mr. Griffith.
Judge, I filed a stand your ground motion that needs to be set before the court.
Yeah, needs to be a day. Needs to be a day.
We'll need that one day for that motion, Your Honor.
A full day?
That's what the state just indicated to me, Judge. Can we go ahead and have your judicial assistant and our assistant schedule it? Because I don't have my calendar here to be able to set a full day.
We'll need, so state agrees it'll take a full day?
I believe so.
And about how much time, and we're handling Mr. Griffith's case, but I know you have Trevor Brown as well, so I wanted to have you here for your side of your case as well, Mr. Nopes.
Yes, sir.
How much time do you think you'll need to be ready to have the hearing, just so Ms. Natali can work with you to get it set?
I need at least a couple weeks, Your Honor. I've got to get some transcripts.
I would agree, Judge. I know I've got two second-degree traveling cases scheduled over in Escambia County, so.
Okay, and so I'll have Ms. Natali reach out and get that set for you, and so I'm saying it's one full day. You'll need at least a couple of weeks' notice to have everybody lined up, and she'll get with your offices and get it scheduled.
Thank you, Judge.
Okay?
And if the state could just put on the record, there are no offers to Mr. Brown at this time. There will not be any offers to Mr. Brown.
Okay, understood.
Thank you.
All right, so is that all you have today, Mr. Griffith? You have-
No, sir. I have Darius Wingate. That's a co-defendant with one of Mr. Cobb's clients that he continued.
Okay, and let's take care of Mr. Nopes with Mr. Brown, and then we'll get back to Mr. Wingate, okay?
Thank you, Judge.
So, Judge, for the record, Marty Nopes on behalf
Correct.
of Trevor Brown, 24 CF 2826. Judge, I was just appointed on April 28th. I do not have any discovery yet. I have met with Mr. Brown yesterday and discussed the case briefly, but I believe I need to get discovery and maybe take a deposition. So I'm asking to continue.
State?
Your Honor, there's no objection. If we may approach for a moment.
Granted.
Thank you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, matter will be continued one cycle. Do your due diligence, Mr. Nopes.
On Mr. Brown's case, sir, is that July 11th?
It's 7/14.
7/14, okay.
Correct. I'm right, Madam Clerk, right?
Yes, Judge.
Okay.
Thank you, Judge.
Last time I was handing out the wrong dates. I'm just going to be sure.
Now, that can confuse people.
Oh, yeah. Well, Mr. Nopes, you know my rule. I don't schedule and I sometimes break it and then get in trouble, so. I know my superpower does not lie in scheduling, so I'll let somebody else handle that. All right. All right, thank you very much, Mr. Brown. Next case for,
I have Darius Wingate, Judge. Judge, on Mr. Wingate's case, there was a problem with discovery, so the state kindly redid all the discovery and ran into trouble with their IT people, and we ran into trouble downloading what we got. It ended up that we sent over a 2 terabyte external hard drive, and they were able to get all of the discovery downloaded to that. And where we are right now, we just got it, I think, last week, and we're just going through it to see what additional witnesses we need to depose and what other evidence there is that the state's provided us. Apparently, the state received the discovery in batches, and in an effort to be sure they complied with Brady, they redid all the discovery, so we now have everything.
and so you're asking for
I'm asking for, I think, if you do a one-time continuance, I don't know that we'll have everything done, but as far as just keeping it on track, a one-time continuance may be the most advisable thing to do.
All right. Well, considering what you've told me, I'll continue at one time, but I would suggest what you should do is get with the state after you've got your feet under you on the discovery. And I don't want to make you come back to court just to say we need another continuance to do our depots or whatever. If that's what you see and you can arrange to get those depots scheduled, then just get me an order that says that we're taking the followed depositions and here's the schedule of it, and I'll continue the case. I don't want to bring you back to court just to check the box. That's silly.
I appreciate that, Judge.
All right. So we'll reschedule it for status on 7/14, but after you get your feet under you with the discovery, reach out to the state and schedule all that stuff, and I'll continue it without the necessity of you being present.
Thank you, Judge. I appreciate that.
Okay.
That concludes my business before the court.
Thank you now.
Next will be Toriano Marsh.
Your Honor, I haven't seen Mr. Henderson.
Say again?
I have not seen Mr. Henderson anywhere. I know he's the attorney for the defendant.
Henderson? Tony Henderson?
Yes.
Tony Henderson.
He's in Boston.
He's in Boston?
We need to check, that's why Ms. Sanderson, yes. I'd be happy, my name is Gene Mitchell, I'm happy to stand in.
Tony Henderson.
Well,
I tell you, I'll give him a call, I'll be right back.
All right, so we'll go to the next person after that. Because Mr. Harsher was here Monday for Mr. Henderson, right?
Correct.
Was Mr. Harsher not in the courtroom earlier? I thought,
I personally did not see him.
So Judge, on Mr. Gamble's cases.
Yes, sir.
The one case we did go to trial on.
Yes, sir.
And I know that Mr. Gomez sent a sentencing letter yesterday. I didn't know the day was set for sentencing. I thought what my notes showed was that you wanted to do a status, basically, to figure out where we're at. But I think the matter needs to be set for a sentencing date. And that's what I spoke with my client about yesterday.
right. And I checked my notes in preparation for the docket, and I thought that we were going to have the sentencing on our second miscellaneous day of May, but, you know, we were moving fast towards the end, and I don't think it actually got set. That's what my personal notes say, but I'm not sure that got adequately conveyed, and I'm not blaming anybody. We were just moving real fast towards the end of the trial. And that wouldn't that be the 22nd?
Yes, Judge, be next Thursday.
Can you be ready on the 22nd, considering the time?
Ready today.
Say again?
I'm ready to get sentenced today.
You ready today?
Judge, as long as he's ready, and that's fine.
All right. So and the state's obviously ready. All right. All right. And so that would be on the one case we tried, which is the 22
CF 2532, Your Honor.
2532, right? All right. So, score sheet?
Yes, sir.
Yeah, absolutely. Just review it with Mr. Nopes. We need to have consensus. All right, so with that change, any score sheet objections, Mr. Nopes?
No objection, Your
Okay?
So Judge, I understand there's minimum mandatories, and, you know, for the charges, there's certain things that there's no deviation from because of what the statutes tell us. So I'm simply asking the court to give Mr. Gamble the statutory minimum for each of these cases, and to run any time concurrently between any of the cases or counts, and then basically give him credit for time served. But I'm not gonna stand up here and ask the court to give him something that's not legally allowed. So we understand there's minimum mandatories, and we're simply saying that that would be what we would ask the court to do. He's got children, and, you know, the unfortunate part is the minimum mandatories are 25 years on the one charge. And, you know.
That's on count one, right? The minimum is 25 years, minimum mandatory on
Right.
count one, right?
Right. So I think that's the best I could hope for and the best he could hope for, and that's what I'm asking the court for today.
And then count two is a minimum of 7 years mandatory.
That's correct, Judge.
Okay. And then count five, based upon his score, he would have to be sentenced to the 60 months on count five, right?
That's correct.
I mean, count four.
Yeah, the third-degree felony.
Count three would be 60 months, which is the maximum based upon his score sheet.
That's correct.
Okay, all right. That's, you understand that that would be the requirement of the sentence on count three as well, based upon the score sheet?
Yes, sir.
Okay. Mr. Gomez, state's argument.
Yes, Your Honor, I laid out our position in the letter that I had sent. Simply for the state, and looking at the defendant's criminal history, we see, you know, he starts off in about 2012 at these misdemeanor charges, and then we see possession of marijuana greater than 20 grams, and then we see sale, manufacture, delivery, and we see this continual escalation until it results in the defendant being found with over 28 grams of fentanyl. Fentanyl is a substance that right now, particularly for our county and our community, is ravaging our community. I hear the defendant talk about and plea for leniency on the sentence because of his children, and the state's position is you should have taken your children into account before you decided to sell this dangerous of a narcotic and to possess this amount of this dangerous of a narcotic, as well as with methamphetamine, as well as with the cocaine. Your Honor, we feel as though the defendant has shown a complete lack of regard for the safety of the community, and we feel as though the sentence should reflect that. That's why we're requesting 30 years on count one, 25 years of it to be a minimum mandatory sentence under the statute, 30 years on count two to run concurrently with count one, 7 years of that being a mandatory minimum sentence, and then we would like 5 years on count three to run consecutively to counts one and two for a total of a 35-year sentence, Your Honor. That's what the state is requesting.
Explain to me why, under the circumstances presented, the court has the authority to make count three a consecutive sentence. Because this is a single criminal episode, isn't it?
Correct. From what I understand of the case law, Your Honor, the mandatory minimums are the only ones that cannot run consecutive under the single criminal episode. If it's not a mandatory minimum, then I believe you have the authority and the discretion to run that sentence consecutively based on what I had looked at.
All right. Mr. Nopes, your arguments,
Judge, to begin with, I don't necessarily think that the facts warrant that consecutive 5 years. I think the case, the just answer is the 25-year minimum mandatory. And 7, but to run concurrently. I don't think, you know, there's this idea of piling on to ask for 5 additional years to be consecutive. I don't think these facts warrant that. I understand the state's position, certainly. However, and the other thing, judges, I'm not certain if the court has the ability, legal authority, to run the 5-year or the third-degree felony consecutive under these circumstances. So
Well, and you know, the court's aware that there are certain statutes that provide specifically that although a single episode could support consecutive sentences, I'm trying to remember, I think the one with the aggravated assault with a firearm with a discharge is one of those where the statute specifically provides that those sentences may be imposed consecutively, even if it's a single episode. The legislature's indicated that those are circumstances where they believe that. But I've heard the argument. So the court's prepared, and you've been here a long time. Mr. Gomez is not. Other lawyers present have heard me. You know, I tell defendants, you know, if you accept a plea, all I know about your case is what I hear in the plea. But when you go to trial, I learn a lot more about the case, and I learn a lot more about you and the circumstances presented. After hearing the trial, you know, the court does find that it is appropriate to impose the maximum sentence in this case. So on count one, it's going to be a 30-year DOC sentence, credit for time served, with 25 years of that as the mandatory according to the terms of the statute. And it's a $500,000 fine with the associated surcharge, and that would be, Madam Clerk, $25,000 surcharge. Count two, it's going to be the 30 years Department of Corrections with the minimum mandatory 7 years, the fine of $100,000 with the clerk's surcharge of $5,000. Count three is going to be 60 months in the Department of Corrections. The court does not run that consecutively. It will be concurrent. And Madam Clerk, fines, other than the fines that are announced, what are the appropriate costs? $615. You're appointed in this case, right, Mr. Notes?
That is correct.
And so it will be $100 cost of defense and $50 examination fee on top of that. And of course, that's credit for all time served.
Yes, sir.
All counts concurrent, yes, ma'am. Cost to collections.
Thank you, sir. Thank you.
Now, what about the other cases?
Give me half a second, Judge.
Yes, sir. All right, we'll leave it for status on docket day.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's...
Judge, I just want to put on record that I want to put my appeal through.
Say again?
I just want to put on record that I want to put my appeal through.
Yes, sir. You can chat with Mr. Nopes about that, and he'll take care of it.
I've told him, my office is ready to put it together, and I just want to put it on record.
Yes, sir.
He just wanted the record to reflect that.
So noted.
Judge, you want me to go ahead with my cases?
Next will be William Law.
Good, okay. Judge, on Mr. Locke's case, 25 CF 46, Judge, we've got deposition scheduled, I believe, for June 11th. I've also had him evaluated by Dr. Harper. She'll have me a report maybe next week. But I'd like to continue it so that I could do the depositions and see who shows up and what actually gets signed.
No objection from the state, Your Honor.
All right, so Dr. Harper's already visited with your client?
Yes.
Okay, all right. All right, and the continuance is granted.
Okay.
Thank you.
Thank you. All right.
Next one is Devin Moore.
Judge, we had I'm going to file my written motion to suppress. He had filed one handwritten, I adopted it, and then I had a lady that's what she does, she writes motion reviews, arrest reports and things of that nature. And she sent me a motion. I've given a copy of that to my client. I'm going to meet with him. I plan to meet with him this weekend. If he says it all looks good to him, then we'll file it on Monday, but it probably needs to be set off to continue to the 14th. And we'll get it filed and we'll get a hearing date.
All right, very good. State?
No objection, Your Honor.
All right. And as soon as that's filed, then reach out to get that set, and we'll plug it in as soon as we can.
Absolutely, Judge.
All right, thank you.
Next, Cody Owens.
Judge,
Did you get, did she have a PD originally and then you got appointed? Because. I'll make sure to.
if you tell me, I know you can see if we download, if you send something, I can do that. No. I think the PD and then maybe conflict jumped.
Yeah.
This happened January 30th.
Yeah, I'll make sure to do that.
You've got nothing to do, I mean, I don't want you to put this stuff out.
I know, right?
I've been hanging out with Mr. Snell too much, getting a little lax. Your Honor, on Ms. Owens' case, 25 CF 221, Judge, I just spoke with the state. My office doesn't see that they've sent us discovery. It is a fairly new case. January 30th of 25 looks like the arrest date. But I'd ask to continue it, and then I'm going to be filing a motion to look at the bond circumstances. I told Ms. Owens I'd do that.
And I just made sure, we had sent discovery out to the PD, and then I think the PD got off of it, and then it kind of went through RCC and then to Mr. Nope, so I'll make sure to get the discovery. I already put in a request to get the discovery sent to Mr. Nope's office.
I understand, Judge, that works.
Well, and if y'all approach real quickly.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in...
So, Judge, in line with what was discussed with the court and the state at the bench, we'll be filing a motion to reinstate our bond. We'll get it filed next week, and we'll ask the court team for whatever the next date is and get it on your schedule.
All right. And we'll continue it then 1 cycle.
Thank you, Judge. I'll get it filed. Okay. Judge, this next case, I'd like to hold him and let me talk to Paulson. That's the next case. I went to the jail yesterday, and there was some difficulty in getting him up to see me, and I literally just couldn't stay any longer.
Okay.
So I'd like to talk. I've not talked to him as of yet, and I'd like to speak to him before we have we handle this case this morning.
So if we'll leave him, Paulson, up here so he can chat with Mr. Knowles. Woodhams.
Oh, okay.
Misty Woodham.
So Judge, I'd like to leave this set for Monday. I'd like to talk with the state about the one charge that's got her in a position where she's not able to get out, is that burglary with a solar battery. And I've got a witness that I just spoke with, so if we could leave it set for Monday, I believe the state and I'll get together, and then actually, got one more pre-trial petition here, you and I discussed this case about the facts, and you thought that it was a strange situation. So if we just leave it set for docket day, plea of continuance. What is that?
Tomorrow is my second witness that we're hearing.
Okay. You want me to have this?
Yes, we do. I was going to mail it to you.
Okay.
And it's
Okay, all right, we'll see you on Monday. Now, is it Woodhams with an S or?
with the S, yes, sir.
Okay, all right, good. Thank you.
Okay, I will see you, okay?
And he does, he must have needed in another institution, so.
I know that. He, I think he got invited to federal court.
So there's Jared Smith.
Okay,
Jared Smith.
Jared Smith.
That's me. Excuse me, ma'am.
Judge, Jared Paul Smith, 25 CF 180 and 24 CF 2536. Judge, I was just appointed May 7th. I did meet with him yesterday at the jail. I told him that I need to get the discovery and take depositions. He also discussed with me a speedy trial motion. I told him that we come to today and I'd leave it set for Monday for docket day, knowing that the case is not going to go to trial this go around, but that way the state doesn't have a chance to talk and maybe we could get something figured out. But he does want me to file a demand for speedy trial.
All right. Is the state got an offer?
Months, 40.425 months, DOC.
No, nothing to follow, just straight time. And that's on both cases, and that's a guideline sentence.
Yes, sir.
And what's the maximum exposure here for the defendant?
I would think
10 years.
Okay. All right, we'll see you on docket day. Is that going to be plea or continue, Mr. Noakes?
Clear continue this go around, Judge.
Okay. See you on docket day. Thank you.
Thank you.
Next one will be Michael Thompson.
I'm sorry?
Are you got one for Dale, Keon for Dale?
Yes, sir.
So we'll have him come up there.
So, Judge, on Mr. Thompson's case, 25 CF 211, Judge, I'd ask to put it on for Monday, clear continuance. I'd like to have a chance to talk to the state between now and Monday and kind of get them to understand. I think there's problems with the case, so.
All right. Is there presently an offer?
Yes, I think
That's a guideline as well. Uh, 22 months.
And just straight time, no probation to follow?
Correct, yes, sir.
All right, we'll leave it on for docket day, plea or continue.
I'll come talk to you, okay? So let me just double check. I think they've got Mr. Purnell coming out, Judge.
And on the case Miss Dudley had with him, she got an amended offer, and we left it on for plea or continue on docket day. And Mr. Nopes, while we're waiting on Mr. Purnell, Pineda, you said is in another institution, is that right?
Judge, I'm
He's
glad
in-
you brought, I was about to come back and ask what date we were going to put him on. Judge, I believe he's in federal custody. And the only reason I know that is his public defender in federal court reached out to me, and the state and I have been communicating about what they may or may not do with this charge based on what happens in federal court. So, yes.
Do we want to just continue one cycle, and if you have something else, you can just bring it in earlier?
Absolutely.
State?
That's good with me, Your Honor.
All right, so it'll be continued to the next cycle. Thank you.
As I expected. You got to continue, but, okay. Well, actually, not, your case is going to get continued. I was on that one. Yeah, but your case is going to get continued, okay? We've got depositions set in June. Purnell, 24 CF 2414. Judge, we've got depositions scheduled in June. So I think, actually, you want to leave it? No, we're not leaving it. We'll continue.
No objection.
All right. And after that, you expect anything else? Or we're going to depots in June, or it just depends on the outcome of that?
Judge, can we approach?
Yes.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than
All right, so
70 years,
we'll leave it
the
for
sweet
continuance,
aroma
finish your
of the
depositions, and
Crestvew's
then we'll
Coney
move on
Island
from there.
burgers and hot dogs has permeated
Mr.
the
President.
downtown area. If you have not experienced the unique flavor of Crestvew's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m.,
Henderson
and
asked me to
Saturday from
cover
10 a.m. till 2 p.m. We're
Mr.
located in historic
Mr.
downtown
Mrs.
Crestview at
Marsh,
107
24
North
CF,
Main Street.
2814.
Call.
And I guess he's out of town and won't be back till May 20th, so he's asking to set it for trial. So he's asking for it to be, he's ready to go to trial and asking for the jury review date. And I'm assuming, Mr. Gomez, you're aware of that?
I am now. I was a little bit, so I'll bring this up, and I don't know how we'll resolve this,
Well,
but.
hold on. Where's the defendant? We're not going to discuss that without the defendant being present. Just saying. I mean, it's just a basic rule, isn't it?
That seems fair, Judge.
Granted.
Eight 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right. Is this Mr. Marsh?
I believe so, Judge.
All right. All right, so now we have the defendant present.
So Judge, Mr. Henderson's out of town. They asked us to cover. He said that he's ready to go, the case is ready to go to trial, and that he's asked to put it on for jury review.
Okay.
The one question I had, because originally Mr. Marsh was in front of this court on 22 CF 2119. We then, if I'm not mistaken, once he got this, there was a combination of those two cases that get placed into vet court. I am now looking at 2119, and for some reason it's showing as closed on the clerk's site, even though this one came back on the docket, and the 22 CF 2119 did not come back on the docket. I see that it's reopened on 4/24, then reopened case closed. Then there's a bond hearing held on the 24th of April as well. Nothing in the clerk's minutes indicate that that case should have been closed.
And say again the case number, I'm sorry.
4622 CF 2119.
22?
Yes, Your Honor.
2119?
Yes, Your Honor. And so I'm trying to make sure, because if that case is still open, I want to go on that one first. I've spoken with those victims before. To be quite frank, well, I've had early contact in the 24 case with the victim, but then once it got pled into drug or vet court, my hands were kind of off, and I haven't had an opportunity to speak with the victim in that 24 case. So if we're going to go to trial, I want to do the 22 CF 2119 first, as that is the older case as well.
What's that case number again, Mr. Gomez?
4622
22 CF
2119.
2119. Okay.
It's not clear to me from the minute sheets. It looks like it's suggesting that he was in vet court.
He was in vet court for this case, the case that we're in here today, 242814, and the 24 CF 2119. And then for some reason, the 24 case came back off the docket and onto this one, but the 22 case did not.
Okay. And Judge, he's remained, he tells me he's remained in vet court, and he goes to vet court again tomorrow.
All right, so with that confusion and the state's desire, I'm not sure how I can set the case for trial without his counsel present to engage on that question. I mean, the state
I understand, Judge. I understand.
So,
was Mr. Henderson the attorney of record on the 22 CF 2119?
No, it's a public defender. Which is why I'm like very confused.
so
Well, Your Honor, we actually have the luxury of having the vet court prosecutor here. So he has this case, then he also has this 24 case. Okay. This is now saying that it's closed, reopen case closed. Do you know what happened with this case? It's a 22.
You try to do something nice and say, yes, I'll help you out, and then
It's not closed.
no good deed goes
Is
unpunished.
this case still in there?
Yes.
But the other one isn't?
The newest case that he has is not yet.
Okay.
Unless y'all want to put it in
Okay.
there.
No, Your Honor, I'm good with, now that I understand that, I'm good with leaving it set with subpoenas on this one. From what I understand, the new case is not in vet court. The older case is. So I'm good with moving forward with setting the subpoenas on, to jury review on the 24 case.
all right. And I guess I'm going to be absolutely candid. You know this court's position. There are no pleas after docket day. I don't know that Mr. Henderson has told his client that, and he's going to show up on jury review expecting him to plead to this case.
That could certainly happen. I agree, Judge.
And I'm not taking a plea on jury review.
Well,
Is there a plea offer open to this defendant?
We had offered, my offer was 88.8 months in the Department of Corrections, which is a guideline sentence.
88.8?
Yes, Your Honor.
That's a guideline sentence?
That's correct, Your Honor.
All right. And if and so, Mr. Nopes, since you're standing in, reach out to Mr. Henderson and tell him unequivocally that if he's passing this directly to jury review, there's no plea other than guilty as charged after today.
Judge, I don't necessarily know that I've got,
Your Honor,
I don't know if I've got his cell phone number. I mean, his office call. They say he's out of town.
would there be any way that we can set it for a status then on jury review? If we are able to come to a conclusion, then we can. If not, then
No. Jury review is jury review. I mean, I'm not going to let the camel's nose get under the tent.
I'll just move for a state requested continuance on the case, Your Honor, to 7/14.
Judge, if we can just pass him briefly, counsel here's got his cell phone number, and I'll call him here.
Okay.
So
All right. And Mr. Marsh, this is not about you. This is a lack of effective communication. The courts work differently everywhere, and this is the way I do it. And I want to be sure Mr. Henderson's communicated effectively with you, because I don't want to show up on jury review with him expecting a certain outcome and me saying, no way. Okay? That's what this is about. It's not about you individually. It's about effective communication. And I don't want to prejudice you because your lawyer didn't understand how I was handling things. Does that make sense? So this is not about you.
Yes, sir. And I thought I had court Monday, not today. So I was confused about that too.
Well, it's because you're in jail. So we do folks who are incarcerated today instead of Monday. That helps us manage the schedule. That's all.
Okay, and then is it possible just to continue it till he gets back in town, or?
Judge, I was about to ask for that.
If that, well, your lawyer said he wants the case tried, but if you want it continued so you can talk to your lawyer, then I'll do that if the state's agreeable to that.
I'm sorry, Your Honor.
The defendant said with all this confusion that he would prefer the case be continued so he can talk to his lawyer.
I'm okay with that, Your Honor, and I will make an effort to reach out to Mr. Henderson, and if we can come to some sort of resolution before that 7/14 date, then we'll move it up into a miscellaneous date.
And if you can talk to Mr. Henderson and resolve this communication issue, all you got to do is tell Madam Clerk, and we'll put it back on for docket day, and somebody can cover, and we can figure that out. If it still wants to go to trial, we'll go to trial, right?
Yes, Your
But
Honor.
I don't want to put the defendant in a prejudicial position because Mr. Henderson may not understand what my rules are. Since this is only our third docket back in this division, and I don't think Mr. Henderson, he hasn't been with us very much, and I don't want to do that to a defendant or to Mr. Henderson. That wouldn't be fair, right?
Yes, Your Honor.
Okay. So right now, we'll call it a continuance.
Yes,
And Mr. Nopes, you reach out to him, and if he says no, 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 then somebody needs to get specific instructions from him, be back on docket day, and we'll figure that out, okay?
Yes, sir. Judge, I'll be back after I speak with Mr. Paulson.
Good morning, Your Honor.
Good morning.
Your Honor, John Madden here on behalf of Demetrius Warnbull. This is 25 CF 320 is the case I represent him on, though I believe he also has a VOP case, and I do not recall the number for that one. The new charge that he faces is the reason for the violation in this case, that he's facing. And we have gotten discovery, most of it from the state, although I think there are some outstanding body cams. Also, we do need to do depositions in that case, and I anticipate filing a motion, depending on how depositions go. So I would be requesting a continuance of this case for a cycle in order to get that accomplished.
State?
No objection.
All right, matter will be continued.
Do you want the VOP to track, Judge?
Do you have the VOP track with that, Mr. Madden?
I would be fine with that, Your Honor. Oh, there you go.
And what's that case number, Madam
It's
Clerk?
23 CF 2473.
And Judge, I
There's no
would note
attorney.
that's scheduled for June 12th for an arraignment, certainly has no attorney on the fellow violation of probation.
2073.
2473.
Are you going to be representing him in that, Mr. Madden, in the VOP?
We have not had conversations about that yet, Your Honor. When I was retained for this particular case, the new law charge, Mr. Warnbull had Mr. Catalinic representing him in the violation of probation case. I guess Mr. Catalinic has come off since then. So we haven't had any conversations yet, so I may be, but that's not a definitive.
Okay. But at this point in time, we'll simply have them tracked together, and you'll need to have a conversation with Mr. Madden about that. And if Mr. Madden's not going to represent you, then we need to figure that out.
Yes, sir.
Okay?
Yes, sir.
Mr. McKinney? All right.
Thank you, Your Honor.
Thank you very much. Good day.
Next one is Susan Cole.
Your Honor, Mike Flowers representing Ms. Susan Cole today. The first thing I think that we need to take up, Your Honor, is we are filing electronically, and I have a paper copy of our notice of withdrawal of the motion to dismiss hearing that is set before this court on Friday. So based on that, Your Honor, we won't be before the court on Friday, and that we are withdrawing the motion as well as canceling the hearing, and are going to be filing that just in a moment. I'm going
If you want to
read
pass
this-
it forward now, I'll just hand it to Madam Clerk, and that'll take care of it, right, Madam Clerk? All right. The notice of withdrawal motion and canceling the hearing is accepted as filed in open court.
Thank you, Judge. In addition, in speaking with the state and moving this case forward, we believe if it's okay with the court to set this matter for trial on the July 28th cycle. We discussed with the state witness availability, and I think there was a 2-week cycle, July 28th and the following week, but the 28th is the week that we believe best suits all of the available witnesses, and that's what we're seeking. I believe the state agrees with that assessment.
Yes, sir. One of our witnesses is not available the week of August 4th.
All right.
The state will be ready.
All right.
As will the defense, Your Honor.
And how much time reasonably we expect it'll take?
We think it will take a full week.
A full week, including jury selection?
Yes, sir.
And an abundance of precaution. We may be done by Thursday, but I'd rather be safe
All
than
right.
sorry.
And as far as the number of jurors, considering the circumstances, what do we think we should call with the clerk on as far as the number of jurors?
For 12, we usually do 90.
Okay.
Sensible.
Okay. All right, very good.
Your Honor, that's all we have before the court on this matter.
As you know, both of you, I do a lot of the general voir dire, so if there's any additional questions that you wish the court to ask as part of the general voir dire, put your heads together and get them to me, and I'll do those to help you with that if you wish. Of course, that doesn't preclude you from following up, as you know, but if
Yes,
you
sir.
wish me to do it, because, sometimes the jurors are a little more receptive to the judge asking those questions than the lawyers. So if you want me to do that, simply agree what those questions are, and I'll review them
Yes,
with you
sir.
at our next hearings.
Yeah, we understand the court's procedure. Thank you, sir.
Okay, all right, very good, thank you.
Okay, thank you, Judge.
Thank you now, good day.
Next one is Jeremy Schnur, SCHNUR.
My name is Gene Michelin,
I represent Mr. Schnur on one of his two cases. We have hired Dr. Mark Ruiz. Dr. Mark Ruiz, a couple weeks ago, went out and visited with Mr. Schnur and is waiting for materials that Mr. Schnur has signed releases for. And we have a final continuance. May we have a final continuance for the case that I'm representing Mr. Schnur with?
All right.
Ms. Sandler has indicated no objection.
That's correct, Your Honor. This would be a final continuance, though.
All right, it'll be continued. Now, I guess you're saying final continuance, but based upon what you're telling me, if the reports come back or whatever, is it possible that things may change? I guess.
I think both of us would be quite surprised if it came back suggesting incompetence. The purpose of this is mitigation as we're in negotiations.
All right, all right. And Mr. Koch, you also represent the defendant on one of the cases, right?
Good morning, Your Honor. Yes, sir. In 25 CF 79, I represent Mr. Schnur.
And what, you just traveling along with that request for the continuance at this point in time?
That is correct, Judge.
Okay. All right, very good. Thank you very much.
All right, next one will be Gregory Simons.
Yes. Just, if I could have 2 minutes, I was trying to talk with them earlier, but if I could have 2 minutes talking with them, I would appreciate it.
Sure. I'll just put this obnoxious noise on and you can talk to him right here.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Simons, forgive me, may we put on a clear continuance date? I think I heard you say you had one of those.
For a whole cycle or for Monday? For a docket day?
A docket day.
Okay.
Just to see if anything might be getting worked out, but I don't want to put the state in a position where we have to sit on stairs.
Thank you.
All right. It'll be next Monday.
Look forward to seeing you.
Well, actually, since he's incarcerated, it'll be next Wednesday. Apologize.
Thanks for that.
No, wait, what? I'm sorry. Hold on. See, it's what I was saying about scheduling. It is Monday. Sorry. Docket day is Monday, not next Wednesday. Sorry.
I know I'm selecting juries Monday. Do you think that you'll be going all day?
It depends on what the final numbers are, but probably.
Okay, all right, I'll be coming.
Okay.
It'll be first thing in the morning.
Okay, no problems. Thank you. Thanks for watching out.
Next one will be Michael Ladson.
Say again?
Ladson.
Good morning, Your Honor. It's still morning. Joseph Riassi for Michael Allen Ladson is present before the court in 2022 CF 827. Your Honor, I'd like to have this set for trial. I also have jury selection on Monday in Escambia County. I was wondering if the court would entertain having this set on jury review on Friday.
For what purpose?
I guess it would be set generally it would be set for docket day, and then it would be set for jury selection, and then we do jury.
Right. So you're announcing ready for trial. There's
yes,
no
sir.
The case is going to trial. It's not for disposition.
No, Your Honor.
Okay.
If we could set it directly to jury selection, but I'd like to at least have a chance to meet with the court before we go to jury selection, in case something changes with the state. His offer is 25 years, and right now, and he's not going to accept that offer.
And as you heard me talk about, Mr. Henderson, after docket day, there's no plea that I'll accept, absent some really crazy situation. You know, I like what the judge over in Santa Rosa County said. When you remember when we were having all the thing about the UFOs over in Santa Rosa County, you old enough to remember that?
Yeah.
Yeah. Well, the judge over there said, absent alien abduction, when that was all going on, I'm not taking any plea other than guilty as charged after docket day. So unless something like alien abduction happens, I'm not taking any plea after docket day other than guilty as charged. So if you're expecting to take a plea on jury review, you are mistaken, unless somebody is abducted by aliens.
And I'm not expecting the state to amend the offer that they've offered. I mean, the offer's been the same since the case was initiated, and it's for the last years. Why don't we leave it set on docket day, and I'll make arrangements to have the case covered if I can up here.
All right, and so we're setting it for plea or trial on docket day?
Yes, Your Honor. Plea or trial.
And what's the maximum exposure the defendant has in this case?
I believe 70 years.
Okay, and so the state is offering 25 years? Is that the guidelines or minimum mandatory?
Minimum mandatory, Your Honor.
So the state is offering the minimum sentence, and the maximum is?
Well, I may be I may be giving you the maximum for the case I have going to jury selection on Monday.
I'm pulling up the score sheet now, Your Honor. I mean, the maximum is going to be life.
Right, because the count one is attempted second-degree murder with a firearm, and that's a first-degree life felony, right?
Yes, Your Honor. The maximum would be life. I apologize.
All right. And then count two is possession of a weapon or ammo by a convicted felon, which is a second-degree felony, which is 180 months, right?
Correct.
Yes, Your Honor.
That one's a discharge though, so he's looking at the 20 and the 10-20 life.
So it's an enhanced sentence because it's with discharge, so it's 240 months.
Correct, Your Honor.
And then count three is carrying concealed firearm, which is 5 years. And then he's got 2 misdemeanors. And then count 6 is theft of a firearm, which is another third-degree felony, which is...
The state didn't pursue that count.
They didn't file on that? Oh, that's right, there's no action on that. So The state's offer is the minimum that was permissible, and the maximum is life.
Yes, Your Honor.
Okay. All right, so we'll leave it on for docket day with the understanding that after docket day, the only plea the court will accept is guilty as charged.
Yes, Your Honor. That's all I have before I.
Okay, all right, thank you very much. Thank you, sir. Good day.
Next one will be Nathaniel Riggs.
Yes. Yes.
I'm standing in on behalf and for Mr. Ira Steele, and I think we've already announced that this case is going to be continued and tracked with the co-defendant's case, Mr. Morris.
Correct.
So I just wanted to make sure Mr. Riggs was aware of that, and I told him what happened. So I gave him the date of July 14th.
Correct.
Okay.
And I apologize, there was some confusion about my procedure versus the one that Mr. Still ordinarily deals with, and his order came in a little late. That's the reason we were transported. It was an agreement to continue. It was just confusion about my process. Okay?
He says he would like to address the court.
You probably shouldn't unless you talk to your lawyer first. It's generally a bad idea for a defendant to talk to the court without the advice of their lawyer.
And when he says your lawyer, he doesn't mean me. He means Mr. Steele. Yeah.
I just need to say something.
Huh?
I just need to say something.
He says he wants to say something. I would advise him not to. I'm acting as if Ira was here, and I'm saying you probably shouldn't say anything, so you've been advised.
Well, no, Your Honor, I haven't seen my discovery or anything, and this case has been going on 3 years. I haven't seen anything pertaining to my case. I wrote motions to the court. I asked my lawyer, but I haven't gotten anything.
All right. Well, what we'll do is that if that's your desire, then we'll be sure that we talk about that when your lawyer is present, and I'll require him to be present at the next session, and we'll discuss that with him present, okay?
Yes, sir.
And I'll forward that along to Mr. Steele as well, so maybe he can resolve that issue.
All right.
Next one will be Timothy Anderson.
I believe Mr. Switek is on Zoom.
Yes, he is. All right, Mr. Switek, your client is at the lectern.
Morning, Your Honor.
Good morning, Mr. Switek.
On Mr. Anderson's case, we're waiting for the court's order on the motion to suppress. And then we have a motion hearing, I think, on June 14th, if I recall correctly.
June 12th.
And what's the motion on June 12th?
The Lisa.
The state's motion to exclude testimony of our experts.
The state has not received anything from the experts that the court ordered. The court ordered the experts to turn over the raw data in 5 days, and they did not comply.
Okay. I'll check on the order. I thought I'd completed it. All right, so we'll set this also for status on 6/12 to review that.
All right. And that's all I've got, Judge.
All right, thank you now. All right, thank you, Mr. Anderson. Good day.
Next one will be Kevin Vogt.
All right.
Morning, Your
And,
Honor.
Good morning. On Kevin Vogt, in preparation for today, I've reviewed the proceedings, and the court is finishing up a written order on the two motions. The court has decided to deny the motion to suppress and also the motion to dismiss, and a written order should be in process if it's not currently in my queue in the case.
Okay. Well, obviously, we were waiting for that determination to know exactly where we were going from there, Judge. I get a little bit confused by the descriptive words that are used with the court over here, but the docket day, I guess, would be Monday?
Monday, yes.
And and the court thinks that those orders are going to be available like immediately?
As soon as I get time to check my queue and see if they're there or not, I'll sign them.
Okay, this is Wednesday. If we could just ask for this to remain then and be passed until Monday, and I suppose to advise the court at this time on the basis of what that would be a plea or continuance at that time.
Okay, all right. Very good.
And the time on Mondays at 9, is that correct, Judge?
Yes, sir.
Thank you, Judge.
Thank you.
Next one will be Samantha
Lucas. Who, I guess we've got Ms. Jaquith, right? And Mr. Cobb, who else do you have? Because let's take a comfort break before we move on. It's about time, I think. So we'll hold on with Ms. Lucas. And we'll just
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Oh! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm
We have 2 females right now.
Oh, you can do the females real quick if you need to.
Yeah, Lucas and Melanie.
All right, I'll wait.
Cutter, just a cutter. This is a pro se defender, Your Honor, by the way.
All right, good morning. You're Samantha Lucas.
Yes, sir.
All right, you're here today without a lawyer. Do you want a lawyer to represent you?
If there's one available, I suppose.
Are you able to afford a lawyer on your own?
Well, I've been working on a resolution that might be possible for this case, and I have it with me right now, so.
Okay.
Oh, I'm sorry. I have something like that,
So tell me what it is you are looking for as far as the disposition of the case.
Okay, so I have brought a counteroffer to the state's offer. And basically, after reviewing my score sheet and history of substance abuse while also considering the nature and severity of the pending charges, you'll find that the proposed sentence agreement aligns with the criminal punishment code pursuant to Florida statutes 948.20 and 9.8.04, section 1. And in exchange for a plea of guilty to be entered, the court and prosecution hereby agree to the following, if you do. 30 days incarceration in OCJ with credit for all time served, 24 months drug offender probation with all applicable terms and conditions that may be required, early termination upon completion of all probation stipulations and fulfilling all monetary obligations by 12 months, completion of a substance abuse awareness and prevention course, loss of driving privileges for 12 months with a hardship license allowed for work only, 120 hours of community service to be completed within 6 months, and pay all fines, fees, and court costs. And I understand the terms of this plea and understand that by entering a plea of guilty and signing this plea that I waive my right to a trial by jury.
And so is that about the case, the 23 CF 2139, or is it about both cases that you're looking for?
If you could put them all together, my score sheet would come out to 51.30 points, which is under the 60 points that are required by statute to qualify for drug offender probation. And the charges my primary charges, the felonies, are also under 893.136A.
Because you also have the 25 CF 785, which is set for felony plea next week, and your trial cycle on 7/14. So the state has heard what the defendant has asked for in a self-represented capacity. Is the state in a position to accept what the defendant is asking for in the two cases?
I am looking at something real quick, Your Honor, if I can. I'm trying to do the score sheet with the new 25 charge.
I have it right here if you want to see it.
Did we say that she's going to be back on May 22nd? Because I'm going to need to file information in that case. I'm not saying no to your offer. I need some time to think about it, and I will most certainly get you a response when you come back on the 22nd.
Okay, do you want to take this to make a copy of it?
I got it all down on our notes.
Okay.
Yep.
All right. So, yeah. What I'll do is I'll set both your cases on plea day on 4/22, which is next week. I mean, 5/22, so 5/22. Now, at that point in time, if the state says no, we'll have a further discussion about whether you wish to be represented or not, because you're entitled to be represented at all stages of the proceeding. And if you've got questions about that going forward, and you wish to have a lawyer, then we'll talk about what you need to do that if you can't afford one on your own, okay?
Okay.
So we'll set that on the 22nd, both cases, and see where we are after the state has a chance to review that, okay?
Okay. Thank you
Okay.
both for your time.
Thank you now.
and
Good day.
We're bringing back Stephen Rogers.
Rogers, please.
So just need a minute for Mr. Rogers to execute the plea form. It's 22.425 months AOC with credit for all time served sentences are concurrent for both cases and with the sentencing case number 22 CF 1342. They're going to reserve jurisdiction over the execution of the case for no liability. Judge, this is Mr. Rogers, present before the court in 2023 CF 1804. He'll withdraw his plea of not guilty and a plea of no contest, and count one to the lesser included offense of burglary of a structure in violation of Florida statute section 810.02, and as charged to count two, grand theft. He'll be adjudicated guilty on counts 1 and 2, be sentenced to serve 22.425 months in the Department of Corrections with credit for all time served. These sentences will run concurrent in both counts and with his sentence in case number 22 CF 1342, which is a violation of probation case, and the court will reserve jurisdiction over the restitution amount for 90 days. Can I approach?
And Madam Clerk, that is 810.02 subsection 4 subsection A. I know you were going to need that, so.
Thank you.
Let me put that on here. Subsection 4.
Subsection 4 subsection A.
Can I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Mr. Cobb said, and you signed the written plea form.
Yes, sir.
How old are you?
37.
How far did you go in school?
College.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
All right. Now, you were here earlier. We discussed the potential outcomes, and then Mr. Cobb asked for a short time to talk to you in the interview room, and then he completed this form, and you came back and signed it just now, right? Is that accurate?
Yes, sir.
We talked about the potential sentence that you could receive, what the state was offering, and the circumstances, right?
Yes, sir.
And that's all happened pretty quick right now, but you had been able to talk to Mr. Cobb in the past about all of those potential, and you just made the decision today. Is that a good
Yes.
recap of what happened?
Summary, yes, sir.
Okay. All right. Now, and you understand that you're pleading no contest.
Yes, sir.
And that says to me that you think the state's got the evidence to prove your guilt, and you're not going to contest that.
Yes, sir.
And you understand by making this plea, you're waiving your right to a trial where the state would have to prove that to the jury.
Yes, sir.
And in this case, you'll be adjudicated guilty. And sentenced to the 22.425 months. Always makes me laugh. 0.425 months. Have they got a stopwatch for that?
Right.
0.005 months. But at any rate, months Department of Corrections with credit for all time served. And I believe the discussion before is everyone believes you have all of that time at this point.
I'm at 21 and some change, Your Honor.
Okay, so very close.
Yes, sir.
All right. And you'll have some fees and costs that you'll have to pay. How much time you'll need to get those paid after your release?
I don't know.
Would 18 months be enough, you think?
Yes, sir. Yes, sir.
Okay. And if you need more time, as long as you're making payments, ask for more time, I'll give you. If you're not making payments, don't bother asking for more
Right.
time, okay?
Yes, sir.
Now, you also have the VOP that you're dealing with, right?
Correct.
All right. And as to the VOP, do you understand you're admitting the violation?
Oh, he's already been sentenced.
Yeah,
on that.
that's-
Oh, that's already taken care of?
Yes, Your Honor.
Yes, sir. 36. He got
He-
36 months sentence on that
Mhm.
with credit for time served.
So that's already disposed of. And so
Yeah.
you're just saying that this is concurrent?
Correct.
Okay, that's confusing because of the two different inks. So that's already disposed of, and all you're saying, the only reason you're putting on there is because it's concurrent with this sentence?
Yes.
Okay. All right. With that, has Mr. Cobb answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Oh, yeah. He has a question about the appeal, but I told him I'd give him a copy of the initial brief that was filed, but that's got nothing to do with this.
Okay. All right. So you satisfied with how you've been represented?
Yes, sir.
And answer all your questions?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
All right, thank you.
Next will be Naomi Cantrell, Cantrell.
Katie Jacob on behalf of Naomi Cantrell and 24 CF 525 and 25 CF 311. Your and I just received the discovery in these cases last week, so I'll be requesting a continuance. And I have met with Ms. Cantrell. She didn't even know that I had the discovery because when I met with her, we didn't have it yet, so. She's aware though.
State has no objection, Your Honor.
All right, matter will be continued one cycle.
Thank you. Your Honor, I believe we're going to have Angelica Walker next.
Walker?
At this time, Your Honor, Ms. Walker is only on the docket for 25 CF 466 case. She does have multiple VOP cases as well as a second new law case. Those case numbers are 23 CF 1508, 24 CF 2594, and 25 CF 16. Those are all already set on the July docket. Because her new law case, 25 CF 764, is set for the July docket. That is also set with Mr. McKinney for plea day tomorrow. My understanding is that the PD's office has withdrawn from the VOP cases, however, they do not have a conflict with the new law case. And so I'm expecting to get those VOP cases. Additionally, I do not believe we've received the discovery in the 25 CF 466 case, so we're not in a position to resolve these and would ask to continue them to the July 14th docket as well.
The state would not object to that.
All right. So the other case numbers say again that
So the new law, the other new law case is 25 CF 764, set for plea day tomorrow and then the July docket.
Correct, that is my case.
and you'll be withdrawing or not?
Not in that case, Judge.
The other cases are 23 CF 1508, 24 CF 2594, 25 CF 16. And I believe the court either has or is getting an order from the PD's office, appointing my office to those cases. I'm just waiting for that order to be signed.
My office has determined that the conflict does not exist with 25 CF 764. So we would be keeping that case. It's scheduled for plea day tomorrow.
All right. All right, as to the 466, then we'll continue that, and then we'll deal with the other ones tomorrow.
And information has been filed.
And information has been filed in the,
So we would be in a position to acknowledge the receipt of that information and our plea of not guilty. So that all of the cases can travel together. And then obviously, if there's a resolution prior to that date, it could be added back on for an early resolution.
As soon as we have a resolution, Judge will add her to an earlier date. But for right now, I think we just need to continue everything to the 14th.
all right. Madam Clerk, you got all the case numbers.
I'm missing one. You said 23 CF 1508 and then.
24 CF 2594?
I got the rest.
And you got the other, okay.
So we want all these to travel together on the 714 docket.
Correct, Your
correct?
Honor.
You agree, Mr. McKinney?
Madam Clerk, that would take her off of the arraignment docket tomorrow.
Yes.
I have to have your VOP cases before I can set up for the bond hearing, so until the order signed from your office, I can't set anything. As soon as I get that, we can talk about it, okay? At this point, it's completely out of my control.
Yeah.
Okay.
Okay.
Okay. All right, thank you.
Next one will be Brendan Carson.
Your Honor, this is Brendan Carson before the court in 22 CF 1148. Mr. Carson is aware, but, I know that, so I'm going to kind of summarize quickly because I know the court's already heard this several times with Mr. Luna and Mr. Wingate, that the state provided a bunch of new discovery. Well, I don't know if it's new, but I've got a bunch of discovery that was handed over on a thumb drive, and I have not had an opportunity to look through that to make sure there's nothing new in his case that we didn't previously have. I'm working through that, but obviously it's pretty voluminous. I think it didn't fit on my 1 terabyte hard drive, so we had to get a second. So as the court is aware, that's a lot of information to go through. But I've made Mr. Carson aware of that. He knows what's going on. The only reason I didn't continue Mr. Carson ahead of time is because he hasn't been to court in probably 7 or 8 months, and I wanted to make sure that the court did lay eyes on him and make sure that the court knew that there was no complaints, there wasn't any issues with Mr. Carson. He's not having any issues with me. There's no issues between the two of us. But in the future, I'll go back to filing a motion to continue with a proposed order. But I did want the court to have the opportunity to lay eyes on him and also have Mr. Carson have the opportunity to be in court, just so that, given the amount of time and the different prosecutors, and again, I've made Mr. Carson aware of all the reasons for the delay, but, and he's not upset about that. He understands what's going on, so, but I did want to make the court aware, just to let him come to court this time, but going forward, we'll continue.
All right. State?
No objection, Your Honor.
All right. It'll be continued. Thank you.
Next one, we have Clifford Meggs.
Your Honor, this is Clifford Meggs before the court. His case numbers are 24 CF 2919, 25 CF 125, and 25 CF 762. We added 762 yesterday to resolve with the other two cases.
25 CF 762?
That's correct, Your Honor, so I'm not sure if it made it onto the docket. But I know that I did also email Madam Clerk and made her aware of it.
And you prepared, Madam Clerk?
You didn't date this.
Yes, Judge.
Okay.
And I apologize, Your Honor, I need to pause for just a moment. Mr. Gomez didn't date the plea agreement, and I know the court's gonna ask him to do so. And with that, Your Honor, we have reached an agreement with the state. As to 24 CF 2919, Mr. Meggs will plead to the lesser included possession of controlled substance, 893.13 sub 6 sub A. And the state will null cross count 2. If I may pause for just a moment. And I apologize, Your Honor, when I met with Mr. Meggs, we went over the issue that I was gonna have to add the restitution amount in this morning, and I forgot that I had done that, and I needed to make sure that he didn't change his willingness to enter into the plea, which he's indicated he does not. The agreement for that case is a withhold of adjudication, 3 years probation, $40 per month cost of supervision. I am gonna be asking that the court waive that cost of supervision so that he can put his funds towards restitution. $615 in court costs, a $150 cost of defense. He needs to submit to a substance abuse evaluation within 30 days. Begin treatment, if any is recommended, within 60 days. No controlled substances without a prescription. He will need to submit to random urinalysis. 48 hours of community service work. No contact with Richard Starr, that's S-T-A-R-R. No trespassing at 8183 Navarre Parkway in Navarre. $1,253.66 restitution to Richard Starr, same spelling. That is joint and several with the co-defendant, and it'll be concurrent to all other counts and cases. Again, count 2 will be dismissed. As to 25 CF 125 and 762, he'll be pleading as charged. In both of those cases, he'll have a withhold of adjudication and 3 years of probation concurrent. There is $515 in court costs in each case, a $100 cost of defense in each case, and again, they are all running concurrently. Your Honor, we do have one matter to address that's not related to this plea agreement, so I just need to make sure Mr. Meggs doesn't walk away once we get this resolved. May I approach? And there is no objection to this motion.
Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Jaquith said on your behalf,
Yes, sir.
and you signed the written plea form.
Yes, sir.
How old are you?
25.
How much schooling do you have?
High school education.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form what Ms. Jaquith announced to me.
Yes, sir.
Do you understand by the terms of this plea agreement that you're pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe that the state has the evidence necessary to prove your guilt to the jury, and you're not going to contest that.
Yes, sir.
Do you understand by making this plea that you're waiving your right to a trial by jury where the state would have to prove that?
Yes, sir.
In this case, adjudication will be withheld, and you're going to be on 3 years of probation with the fees, costs, and other conditions that were announced, in addition to the standard conditions in the plea agreement.
Yes, sir.
A few of those special conditions are your community service and no contact with the victim in this case, and not being at or about the property that was announced. Do you understand that?
Yes, sir.
In addition, you must have a evaluation and do any recommended treatment regarding your substance issues.
Yes, sir.
Ms. Jaquith answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
And the cost of supervision, Your Honor?
Cost of supervision will be waived.
Thank you, Your Honor. Now, as to the collateral matter, when law enforcement went to serve the warrant for the most recent case that we just entered the plea to Mr. Meggs, they knocked on the front door, he ran out the back door, so he had a warrant pending today for a misdemeanor resisting arrest without violence. I've spoken to Mr. Gomez, and we're gonna ask that the court set a bond in that matter. Mr. Meggs, the bond on the warrant was hold for first appearance, no bond. So since he's obviously missed first appearance today, I would just ask that the court set him a signature bond. Obviously, he's gonna be on felony probation, so we'll have that tracking of him as well. And it is just a misdemeanor resisting arrest charge.
I would have no problem with 2,500 signature bond, Your Honor.
All right, so I guess I'm just worried about what may have happened this morning since he didn't make first appearance this morning.
They didn't take him to first appearance, he was already here.
Right.
So I was informed by court security that he had a warrant and that it was no bond, hold for first appearance. Obviously, he missed first appearance today, so they were serving it on him downstairs before they brought him up. So he has not, they've just now served that warrant on him.
Oh, okay.
So we're just basically asking that the court hold a
So
first
he
appearance now.
wasn't scheduled for first
No,
appearance?
he was not.
Okay, that, you understood my confusion?
Yes, I
Okay. Okay, all right, so with that, you gonna send me an order on that?
I will
can-
absolutely.
I guess, but do we have a case number on that yet? So,
But I believe since they just booked him, they're able to change that by court order in the system. My understanding is, and at least the way we've done it in the past, that they can change it downstairs pursuant to the court's order so that he would have a signature bond. He still has to go back to the jail anyway, obviously, to be out processed before he can be released. But I can definitely provide the court an order, and I do believe that Mr. Meggs is gonna be asking to have a public defender's office appointed for that case, so I'll provide the court an order. I guess I can't provide an order if we don't have a case number. So,
Right, well, so I'll do the $2,500 unsecured bond and provide for the appointment of public defender on a provisional basis. I guess my concern is, how do we accomplish that? Part of the reason, and y'all know me, right? I keep Holmes on my desk, right? The life of the law has not been logic, it's been experience. So if I do this, what I don't want to happen is Mr. Meigs go back to the jail and sit there waiting on this ghostly order that's supposed to appear without a case number that lets him out. I guess that's my concern, because since he's engaged in and out of the ordinary process, I want to be sure that it happens. So if you would take on getting an order for me, then I can simply tender it to the bailiff so that they can provide it to booking. It doesn't have to have a case number, it just says, you know, if you put the OSCO incident number, which you will have on the arrest report, on there, that will be sufficient then for it to get to the booking and for them to provide to the jail. I just don't want it to not work through the system, if that makes sense.
Absolutely, Judge, and I will get that typed up and get it over to you as soon as I leave here.
Okay.
And then I will also monitor and make sure that Mr. Meigs is out of jail by tomorrow afternoon, so that if there is any hiccups, we can address it before the end of the week.
And if you'll email that to Ms. Natali and provide in there the appointment of the PD, what I'll do is then when I sign it, I'll serve a copy by email on the PD, so that at least they'll have it in their hand like they would on the first appearance paperwork, if that makes sense.
Yep.
Okay?
Sounds great.
All right. That way we'll close the loop on everybody.
It's a misdemeanor. You guys are still gonna have a conflict, but I know we gotta go through the process.
All right? All right. All right. Thank you for bringing that up.
Yes,
Appreciate that.
thank you.
Okay.
I will check on you. If there's any issues, we'll get it fixed, so don't freak out, but I will look at it, and I will get the order over, okay? All right. Yep.
All right, next one, we have Martin Sanchez.
Madam Interpreter, raise your right hand. Do you swear to interpret these proceedings truthfully, subtracting nothing and adding nothing? All right. Mr. Cochran.
Good morning, Your Honor. Today we have a negotiated plea in this matter. This is Martin Sanchez, case number 24 CF 0957A. In exchange for a plea of no contest, the state has agreed to dismiss count 1. Counts 2 through 4 will be plead as charged. The adjudication of guilt with credit time served. Cost of $150 for cost of defense. No other terms, Your Honor.
Please. Oh, that's okay.
We just have to sign.
And it would be $300 in court costs. Raise your right hand, please. Do you swear or affirm to testify truthfully under penalties of perjury? You can put your hand down. With the help of the interpreter, were you able to understand what Mr. Cochran said?
Yes.
Do you understand that you're pleading no contest to these charges?
Yes.
By pleading no contest, I understand you to say that you believe the state attorney has the evidence necessary to convict you of the charges, And you're not going to contest that?
Yes.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove that?
Yes.
Has Mr. Cochran explained
Le explicó
the effect of this plea on you?
los riesgos de este acuerdo. Yes.
Has he answered all your questions?
Preguntas. Yes.
And are you satisfied with how he's represented you?
Con su representación. Yes.
I apologize for the minute. The form is just in a different format, and it took me a minute to be sure that all of the boxes were checked. The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Next, Your Honor, if I could have a minute with my next client, I just got an offer, so I
Yes,
asked
yes.
to skip on him.
And Mr. Nopes, who do you have left?
Yeah, they've got Mr. Paulson left. Joshua Paulson.
Did you have a chance to talk to him?
I did, Judge. I was waiting to see if maybe the state, I never.
I mean, I spoke with him, but I don't think there's ever an agreement between us to do it. He asked for me. We can try to come up with something up there.
Judge, the state got agreed to put it on for Monday, and I told Mr. Paulson that, we probably couldn't get it resolved today. This is a brand-new case for me, but I'd like to try to help him if I could.
Clear, continue on docket day then?
Yes, sir.
And you have an offer, but you expect that you'll be able to massage that, is basically what you're saying?
I actually do not have an actual offer, but Mr. Koch and Mr. Gomez had been discussing the possibility of getting something worked out, and so this will give Mr. Gomez and I time to continue that
Okay,
conversation.
all right, very good. So we'll leave it on for docket day, clear, continue. Now, is that all for you, Mr. Nopes?
That's it, Judge. Thank you.
Madam Clerk is nodding in agreement, so thank you, good day. All right.
Yes, you can send online. Form.
Next one will be Robert Keats.
There's Pete's.
Judge, this is Mr. Robert Peets in 25 CF 414 and 23 CF 2683, Your Honor. Your Honor, I'm seeking a one-cycle continuance. Currently, the alleged victim we try to depose is she is in custody. Mr. Nopes is her attorney. Mr. Gomez is aware of this, that we need to finalize this last deposition. So defense is seeking a continuance, Your Honor.
State has no objection, Your Honor.
All right, matter will be continued.
The next one will be Matthew Parham.
Judge, this is Mr. Matthew Parham in 2018 CF 77. If I may have a brief moment for Your Honor, this will be a no contest plea this afternoon. All counts as charged will be adjudication of guilt, credit for time served, $615 in court costs, $150 in defense costs. All counts to run concurrent. If I may approach with a signed plea form and score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you put your hand down. You heard what Mr. Koch said and you signed the written plea form?
Yes, sir.
How old are you?
42.
How far did you go in school?
I graduated.
You able to read and understand the form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read, what he just said?
Yes, sir.
Do you understand you're pleading no contest to the charges?
Yes, sir.
That says to me you believe the state's got the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
You understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
In this case, you'll be adjudicated guilty, get credit for time served with the fees and costs that were announced, and all the cases are to run concurrent. How much time will you need to get your fees and costs paid?
60 days, 30, 60 days.
You think that's enough?
Yes, sir.
Mr. Pham, Judge, he does have to go back to Arkansas because will be released on parole in Arkansas. If we can get a year to pay, just
Okay,
because.
okay, yeah, I thought it was to my way to start, right?
Just to get his affairs in order.
Yeah, so a year enough? 12 months?
That'll work.
Okay.
Thank you. Thank you, Judge.
All right. And all questions been answered? And you satisfied with how you've been represented?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
All right. Thank you. Guys, open Arkansas. Yes, sir.
This will be Baricus. Richard Baricus.
Judge, this is Mr. Richard Perikas in 25 CF 207. Good afternoon, Richard.
Good afternoon, sir.
Your Honor, I'm seeking a one-cycle continuance. There is a pending evaluation that needs to be conducted.
There's no objection.
All right, matter will be continued one cycle. Thank you.
Next will be Derek Pugh,
Just on the document.
UGH.
Soon.
Derek Pugh.
And Judge, this is Mr. Derek Pugh, 24 CF 2328. Judge, we completed a deposition on a civilian witness on May 1st. Unfortunately, the alleged victim did not show. I do believe Mr. Gomez has a new address for that alleged victim, so we are seeking a one-cycle continuance to complete that deposition.
Correct, Your Honor, and just also for the court's awareness, there was extensive damage done to the house. The victim is, she's relatively, she moves a lot. She has a house in California. Right now, she's currently in Hawaii, which is why the last one didn't get served on her. We updated that address. I'm in contact with her. She's also working on getting an estimate for the actual damages that were done. There was quite extensive damages, and so we're going to be working on all of that to make sure that we can be as prepared as possible to resolve this in the next cycle, Your Honor.
All right. Matter will be continued.
To July 14th. Yes, sir.
And next one, we have Brian Quinones.
Judge, this is Mr. Brian Kionis in 24 CF 2213. Judge, I'd like to set this for Monday for a plea or a continuance. We did complete a deposition on April 2nd with a civilian witness. Still outstanding is the forensics, and also there's another witness that me and the state are working to get deposed on, Your Honor. But I would like to bring him back on Monday to talk to a potential offer.
Okay, when you say forensics, tell me what you remember. Judges get a snapshot of the case when you show up. What are you waiting on?
There's bullet fragments that were found on the crime scene, Your Honor, that were sent off as forensic evidence. I also believe there was residue, gunshot residue, that was also being analyzed.
And you say you think there's another witness to depose?
Yes, Judge.
And who might that be?
It was determined through the alleged victim, and I do not want to make any statements. The alleged victim matches the description of an individual that also worked at FedEx for a potential motive that we need to talk to.
And that person's not yet identified?
That's correct, Judge. I believe me and Ms. Sandler were talking about subpoenaing the potential employee records, but we would like to depose that individual.
Right, and you've got to do that to discharge your obligation to your client.
Yes, Your Honor.
Talk to your lawyer before you talk to me.
Judge, I believe I answered my client's question.
All right, very good. It'll be continued then.
And to bring him back Monday, Your Honor?
Yes, for docket day.
Yes, Judge, thank you. In the morning.
Say again? Knopfinger?
Just 1 second.
Yes, sir. And apologize, we're talking about something else, not you, okay? Something else that we're trying to get resolved on another case. And I know people get anxious when we're over here whispering about a case, but it's not about you. Go ahead, Mr. Cochran.
Good morning, Your Honor. Today we're here on Mr. Christian Knopfsinger, case number 24 CF 0957A. Your Honor, at this time we've entered a plea, or we've reached a plea agreement with the state in exchange for a plea of no contest, adjudication of guilt. Excuse me, let me start over. In exchange for the plea, the state has agreed to dismiss count 1. Count 2 will be plea discharge. It will be adjudication, cost of defense of $150 plus court cost.
Okay, so that's a misdemeanor POP.
Yes, Your Honor.
That's what we're doing. Okay. And the cost, Madam Clerk, would be? $270 plus the cost of defense, right?
Yes, Judge.
Which would be 50 and 50, no, it'd be 150 in this case. Okay.
If I may approach.
You may. Raise your right hand for me, please, Mr. Knopfsinger. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
Okay, and you put your hand down. You heard what Mr. Cochran said on your behalf and signed the written plea form.
Yes, sir.
You understand you're pleading no contest to these charges?
Yes, sir, I do.
Waiving your right to a trial.
Yes, sir, I do.
You'll be adjudicated guilty, sentenced to time served, and you'll have the 275 plus the 150 that were discussed in court costs that you'll have to pay. How much time do you think you'll need to get those things paid?
I'm gonna probably need a year. I'm disabled, and I had just got taken from my disabled list because I came to jail and everything.
Do you think 12 months is enough time given that? Would you like some more?
Maybe a little more. I don't know. I had a brain injury, and it's hard for me to.
Okay, I'll give you 18 months, and as long as you're making payments,
Yes, sir.
you can ask for more time. My goal is to be sure you get it paid.
Yes,
I
sir.
want you to see a light at the end of the tunnel.
Yes, sir.
And get it taken care of.
Amen.
So start making payments as soon as you can, and if you're making them and need more time, I'll give you more time. But if you don't make any payments, don't bother asking,
Yes, sir.
because the clerk's just gonna send it to collections, okay?
Yes, sir.
Start making your payments, and let's get it resolved, okay?
I'm
Now,
released today, right?
you should be, yes, sir. If you get back in time, they should process you and you get out.
Amen.
All right? As Mr. Cochran answered all your questions about the
Yes.
plea and how it affects you.
Fantastic job.
Okay, I'll find the pleas freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you.
Thank you, Your Honor.
Next one will be Robert Reed.
Your Honor, I believe that's all the cases that I have on the,
I have Roderick McKinnon Jr. that's on the docket, but I guess he wasn't transported with Mr. Cochran and Mr. Gomez.
I think he was continued, I
Yes,
thought.
Your Honor, I filed a motion to continue on that matter.
Okay, there's the order hasn't been in the case.
Okay, so you on Roderick McKinnon Jr., we're saying it's continued, is that right?
That's correct, Your Honor.
Let me just check my list here before we get to. Yeah, I don't see that it was, but we're agreeing to a continuance.
Yes, Your Honor. I know, I told.
Yeah, thank you very much. All right, so now, what we were whispering about up here was Mr. Robert Reese and about how he's here today and he's showing that he's in jail, but he also has active process because of the direct file by the state that he has not been served with. And this is a hiccup in the process. And we could probably go straight on, try this case, get a disposition, and it would still show an active service even though the case was closed. So that's what I was dealing with. So how do we get that direct file served on him? Can you do that right now? Do you show it as an active warrant?
I did not, so this morning we ran, we didn't come up with anything for him. We had one for Morris and one for Miggs. That was the only two. We have nothing for Reese. I can have to check again, individually and see what we're going with.
Because we're showing the, and once again, this is about being sure the process is completed and everything is done correctly. because I don't like those loose ends to be left out there, right? So I want to be sure that's squared away. So it may simply be we have not, the clerk has not received the return of the service. That could be what it is. So double check on that. Let's see if we can get that squared away. All right, with that,
I do have a question. Does that mean that I'm facing another charge?
your lawyer can answer that question. Technically, yes. Practically, no. Typical lawyer answer.
It depends.
Judge, may I just brief
Yeah.
May we approach?
Grant.
David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Thank you, Your Honor. Judge, I was going to, well, first is Mr. Robert Reese, 24 CF 133. We do have a motion to suppress scheduled for tomorrow, but I will turn this over to Mr. Snell, I believe.
Judge, the state is gonna be amended the charge on this case, and I would, probably would negate the reason, the need for the hearing tomorrow. Regardless, I'm gonna need a continuance on the hearing. My officer's not available, but should be hopefully available soon. So I've explained the situation to Mr. Koch about why he's not available. But I've conveyed the new offer to the defense, and Mr. Koch needs to go over that with his client. So that's where we are at this point.
All right, so we're doing two things. We're talking about the case in chief, and we're talking about the motion to suppress, right? All right, so let's talk about the motion to suppress first. What's the defense's position on the request for continuance on the motion to suppress?
Judge, we would object to that motion.
Okay.
And just kind of to follow up, we tried to conduct depositions. There was issue with service because this trooper's out of Pensacola, and then ultimately he's, I guess, put on medical or family leave. I have never once spoken with this trooper. That's why I'm objecting to that motion to be continued.
All right. And the state believes that the lack of appearance and the lack of availability is not willful but is justified?
That's correct, Your Honor.
Okay. Do you feel comfortable doing that in open court, or does that need to be at a bench conference?
A bench conference.
All right, please approach. Now, considering that this is a material issue, I'll permit the defendant to be present during that discussion, even though it's at the bench. Okay? The defendant may be present at the bench during this conference.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Yes, because we're finished with the stuff that needs to be non-public.
Judge, if I may propose.
Yes.
Defense would have no objection to continuing the motion to suppress statements if the state wants to concede to the motion to suppress evidence all those DUI factors we discussed. And I'd like my client to be set for Monday, of course, just so I could talk about this new offer that we received.
Okay.
If the state's willing for that proposal.
He's asking for the state to agree that we would not introduce evidence of field sobriety exercises and the breath test operated situation in
The testing and the refusal, which is the one motion.
Okay.
And based upon your statement that you intend to amend, they would not be relevant, correct?
Correct, yes, sir. So we would agree to that, that'd be fine.
Okay. And so collaborate with an order which says that. I think probably you should wait until the charges are amended.
Okay.
And that would be the basis, right?
Yes.
Get the charges amended. So we'll leave it on for docket day, plea or continue, and the motions to suppress for tomorrow are continued. And we'd expect that y'all will collaborate on an order which will resolve that. I'm just once again using the nomenclature we used at the bench. The testing motion to suppress would be resolved by the amendment and a separate order, and the statement suppression would be reset.
Yes, Judge.
Okay, very good. And an update on the status of the active warrant. Madam Clerk, who deserves 2 gold stars, has reached out both to the sheriff and also to the jail, and they're working on getting evidence. It shows that it has been served. Madam Clerk simply doesn't have evidence of the service of that, and so we're going to work on getting that done so that will be removed from the progress docket. So that'll be squared away.
Excellent. Thank you, Judge.
All right. Thank you.
Next one, we have Nathaniel Reed.
Thank you. Okay. Judge, it's Mr. Nathaniel Reed, 24 CF 1286. Judge, if we can set this for Monday, this will be a trial or plea case. The current offer is a 36 months Department of Corrections. That being said, I have been working with Mr. Snell because we have counters still pending.
So 36 months DOC?
Correct, followed by 36 months standard probation is the current offer on the table, Your Honor. And I did discuss the importance of Monday, docket day, is the last day that we can accept, or excuse me, the court will accept an agreed upon plea deal.
And what is the maximum exposure on the circumstances presented?
Just want to double check.
6 years.
It's a third-degree felony, Judge, so maximum of 5 years, and there's a companion first-degree misdemeanor, so total of 6 years incarceration, Your Honor.
All right, and what's the score sheet show?
He scores 74.4 points for lowest permissible prison sentence of 34.8 months.
So it's couple months more than the guideline sentence.
Yes.
Okay. All right. And so we're setting it for docket day for plea or continue?
This will be a plea or trial, Judge. Like I said, we are working on those counters.
Okay.
And I discussed it with my client, and that's our main focus, but we understand if we do not resolve it on that docket day, it will be set for jury review day, and of course, there'll be no negotiated pleas to the bench.
All right, very good. Thank you very much.
And we have Michael Riley, or Rayleigh.
Judge, this is Mr. Michael Riley, 25 CF 127, 25 CF 189, 25 CF 217, Judge. Judge, I did receive the discovery in all three cases, May 12th. I'm asking for a continuance, but I do want this case set on Monday's docket for a potential negotiated plea, Your Honor.
All right. See you on Monday. But is there an offer currently on the table?
Not yet, Your Honor. No, sir.
Okay.
But I propose counters, Judge.
Okay. All right, very good. Thank you.
Sir.
Next one, we have Robert Riddle.
This is Mr. Robert Riddle, a 24 CF 1789, also a 21 CF 961 VOP, Judge. Judge, if I may have a brief moment. I'm requesting a plea or continuance, but set him on Monday's docket. Just to inform the court or update, we did complete that deposition on that on the alleged victim. That was outstanding. Some issues were brought up with the first count, the PBL, the Berg bat. That's why I'm asking for that continuance and potentially work out an offer Monday.
All right. Is there an offer on the table?
The current offer was guidelines, it was 18 months DOC, and we're working on it. He's proposed a counter offer, and we're going to talk about that.
And the implication there is there are some issues with the fact that this is a PBL, but you believe there is some room there, and then you've got the tampering, which is a first degree, right?
Complete that.
Yes, sir.
Just double checking. Yes, Your Honor.
And then you got the DV.
Correct.
And then the underlying VOP, which is a third degree, right?
That's correct.
So, and so the contemplated, from the state's point of view, that sentence, or your counteroffer is an amendment to the charges, or what are you contemplating?
Could I add to that, Judge?
Yes.
That deposition, the alleged victim, we had an issue getting her to my office, but we completed it, and there are some facts that she discussed. I don't really want to get into exactly, but it involves that burglary element of that PBL. And speaking with my client yesterday at the jail, potentially, if we don't work out a counter, I will have a witness about an issue I don't really discuss. But we did complete that deposition, and we're hoping to work out an offer Monday.
Okay. All right. So we'll set it for docket day.
Thank you, Judge.
Thank you.
Next one will be Wilfredo Rivero Gutierrez.
Thank you, Judge. This is Mr. Wilfredo Rivera Gutierrez, 24 CF 2650. Judge, if we can set this for trial or plea Monday, I did have a lengthy discussion yesterday with my client, and he understands there's no agreed upon pleas after Monday, docket day. My client understands the current offer,
What is the current offer?
11 months, 11 months, 29 days in the county jail, followed by 2 years probation. And my client does not score prison, Your Honor. Total sentence points is 36.
All right. But he does qualify for a prison sentence because he has more than 22 points, correct?
Correct, Judge.
And based on all the charges, maximum potential exposure is 60 months in state prison, right?
That is correct, Judge. My client is aware.
All right. All right, we'll see you on docket day.
Denied.
Next one, we have Angel Rosa Regis.
Okay, I know.
Judge, this is Mr. Angel Rosa Reyes, 25 CF 108, Your Honor. Judge, I am seeking a one-cycle continuance, but I'd also like my client placed on Monday's docket for potential plea.
And is there a present offer?
May we approach?
Granted.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m.,
All right,
and
we'll
Saturday
set
from
this
10 a.m.
plea or continue on docket day.
Yes, Judge. Thank you.
Thank you, counsel.
Next one will be Domingo Sebastian.
Okay, perfect. Thank you, Judge. This is Mr. Domingo Sebastian, 24 CF 2669.
And Judge, state does have an offer for Mr. Sebastian. They would be pleaded counts 1 and 2, 3 years in the Department of Corrections, followed by 7 years of sex offender probation with all of the bells and whistles that also has. Score sheet currently reflects 44.7 months in the Department of Corrections and a maximum of 35 years.
And say again the points?
It would be 87.6 points, 44.70 months presumptively, with a maximum of 35 years. State's offer would be to plead counts 1 and 2, dismiss count 3. 3 years in the Department of Corrections, followed by 7 years of sex offender probation with all the bells and whistles that entails.
Okay.
Judge, may I have just a brief?
Yes.
Thank you, Your Honor. Judge, we did complete the law enforcement depositions in this matter. I'm seeking a one-cycle continuance to review those depositions with my client, because his wish is to go to trial next cycle.
The state has no objection to that. We know that depots occurred, I believe, last week.
Correct.
So is your client rejecting the offer and demanding to go to trial at this point in time? Or does he wish more time to consider that? Because, I mean, that's going to change substantially the court's approach to how we move this case.
Judge, may we approach Ms. Brickman briefly?
Yes. Okay, I apologize for that misunderstanding. Okay, so you want to go ahead and continue that, and so you'll have adequate time to convey that and discuss that with your client.
Yes,
And
Judge.
there's no objection, the offer remains open.
That's correct, Judge.
All right, matter will be continued one cycle.
Next one will be Kimani Solomon.
That's it. Thank you very much. That's not. This is Mr. David Stevens, Judge.
This is David Stevens, this is not Kamani Solomon?
Correct. 24 CF 2740, 24 CF 2743, 24 CF 2744, and 24 CF 2778.
All right.
Judge, I am seeking a one-cycle continuance on all four of those cases. I do have 4 depositions being set with the alleged victims in all those 4 cases. I also provided discovery for my client in all 4 cases. Fortunately, he was in medical. I believe his discovery was stolen from him, so I'm seeking that one-cycle continuance.
State?
No objection to the request.
All right, it'll be continued one cycle.
Yes, Your Honor.
Is there an offer outstanding on these cases so that the court can understand where we are?
Yes, sir. The defense counsel, I approach the bench.
Granted. All right, so with that, you'll discuss you've discussed the state's position on the offer with your client. You believe it's necessary to go ahead and get those depositions taken and have the opportunity to discuss that with your client, resend the discovery so your client will have the opportunity to review that and you'll have a chance to chat with him about that. With that, I'll continue it. The cases are getting a little long in the tooth, right?
Yes.
So as soon as you're able to get that finished, then we'll hopefully be able to get that done by the next cycle, and you can chat with your client about that.
Yes, Your Honor.
And then based upon our discussion at the bench, you'll feed back to Mr. Snell if you have any other information based upon what he's requested.
Yes, Judge.
Okay. All right. Thank you very much. Good day.
Yes, sir. Yes, I will.
We're back with Kimani Solomon.
Judge, this is Mr. Kamani Solomon in 24 CF 1065.
All right.
Judge, I'm asking to set this for trial or plea Monday. That being said, I am working on counteroffers with Mr. Snell. The current offer is the guideline sentence of 48 months. And I did have discussions yesterday, and my client is aware that there's no negotiated pleas past Monday, docket day, but we are still working on those counteroffers that we discussed.
And what's the defendant's maximum exposure as charged?
Just want to verify, Your Honor. It is the F2 15 years on count 1 and the 3 years, or excuse me, the 5 years on count 2, a total of 20 years maximum exposure, Your Honor. With the guidelines being the 48 months and 48-month offer currently, but like I said, we are still working on those counts.
And no probation to follow?
No, sir.
Okay. All right. All right, very good. See you on docket day.
I'll work on those offers that we discussed. Before Monday, after the weekend, hopefully I see you better. I got you. Thank you.
Next one will be Jonas Swayer.
Yes, I already.
Yes, Judge. This is in 25 CF 117.
Yes, sir.
Judge, the alleged victim in this matter, Allison Dudley, she failed to appear for the deposition on May 8th, and she was served. I believe Mr. Snell is requesting to put it on Monday. Of course, clear continuance if you can locate that alleged victim.
That's correct, yes, sir.
For clear continue, is that what we're saying?
Yes, sir.
Okay.
Okay. Just like we talked about. Yep.
The next one will be William Hackett.
Okay. Sorry, Judge, if I may call a client, I'm sorry, she's having, I guess, some medical in the back. She was a client on Monday that unintentionally failed to appear.
Okay, and who is that?
It's a Miss Alexis Richardson in 24 CF 1276. And that was Alexis, last name Richardson, Your Honor.
Right, and I believe she actually communicated with my office, and I forwarded it to, is that right? I believe so?
Yes.
And I forwarded it, I believe, to the state as well, right? Didn't the state receive a copy of that? Her communication from my office? All right, well, enough of that. She's here, and I believe we issued a no bond capias. Is the state willing to withdraw that?
Yes, sir.
Withdraw the capias.
Thank you, Judge.
All right?
She has my contact information, and she knows her next court date is at July 14th.
All right. And is there an offer outstanding in this case? I know.
There might have been.
I didn't see one, Your Honor, just to not hurry it up, but it's a criminal mischief case. I'm already scheduling depositions with the alleged victim, and my client knows to schedule that appointment with me before our next court date.
And the only reason I mention this, because on 7/14, this case will have been pending 13 months. And so it's time to resolve the case, one way or the other. And so that's the reason I'm being pushy, because I want to know what's going on and get this case to resolution. It's important for the defendant to get the case resolved too, right? You know, she just avoided capias and going to jail, and she's here today fixing that. But at the same time, you know, each time we have a court case, right? Oh, and withdraw the forfeiture and as well, please, ma'am.
Judge offer would have been supervision to get the victim made whole. That's the main primary objective there from the state, is that damage would be repaired.
And Your Honor, this was the first time up pretrial. I know the alleged incident occurred 2024, but information was filed March 24th of this year.
Right, but actually, if we look at the whole set of circumstances, the information was filed in July of last year. If I'm right, we're 24/12/76.
24 CF 1276.
Right?
Yes, Your Honor. I apologize. I was looking at when I was appointed. Yes, Your Honor.
And then there was another FTA, and then that FTA was withdrawn. Then there was another FTA, and that FTA was withdrawn. And so I guess what I'm saying is I'm not willing to keep continuing the case under the circumstances presented. We need to move the case forward.
Yes, Your Honor.
And so my inclination is to leave it set for docket day so that we can announce exactly what the offer is on the record with the defendant present to understand where we're going. And so the defendant will know exactly what the situation is, and we can make arrangements also to announce when the depositions are and whatever else you're going to do if there's not a disposition of the case. And if the principal issue here is restoring the victim, the alleged victim, to make them whole, then that needs to be announced, because it's been pending for a year. And time is money, right? And so have you spoken to your client recently, Mr. Koch?
This was the first time I personally spoke with her, Your Honor.
All right. So do you have time between now and docket day to talk to your client?
Yes, Judge.
Okay. So you're going to have to meet with your lawyer and talk to your lawyer. Part of your release is an obligation to participate meaningfully in this case, and that means talking to your lawyer so your lawyer can assist you. And it's clear that you haven't been. And if you continue that pattern, then I'm not going to withdraw the capias again, because if I'm counting right, this is your fourth time doing this. And that's just not acceptable. Do you understand?
Yes, sir.
Okay? So you'll meet with your lawyer. We'll be back Monday. We'll discuss the offer and expect that we'll either move this case forward to a resolution by voluntary plea, or we're setting the case for trial at the next trial cycle so that your attorney will have the opportunity to be prepared. That's the choice. It's not getting continued again. Do you understand?
Yes, sir.
Okay? All right, very well. Thank you.
Good afternoon, Judge.
Good afternoon, Mr. McKinney.
I'm here with William Hackett Jr., 3 case numbers, 24 CF 2573, 24 CF 1370, and a felony violation of probation, 23 CF 183. We've reached an agreement in those matters. We are going to be entering a plea of no contest as charged in the two 24 CF cases and admitting to the violation of probation in 23 CF 183. The agreement that's been contemplated is a negotiated downward departure, adjudication of guilt on all counts, and a new 3-year probation with the conditions of bars to bed Phoenix House. He has been accepted. All of the misdemeanor counts in the new charges, and I believe count 1 in the 183 case is a misdemeanor. Those would be credit for time served. Random urinalysis, substance abuse evaluation and recommended treatment, no alcohol or drugs without prescription. He must maintain gainful employment after his Phoenix House stay. There's a $615 court cost in each of the new cases, a $100 VOP fee, and a total of $350 cost of defense. We're asking that the court waive the cost of supervision while he is at the Phoenix House. May I approach with the score sheet, which reflects that a downward departure is necessary. As stated, it's negotiated. And the plea agreement.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, sir.
How old are you?
39.
How far did you go in school?
I graduated high school.
You able to read and understand the plea form?
Yes, sir, I am.
Did you do that before you signed it?
Yes, sir, I did.
And it's what you read, what Mr. McKinney said?
Yes, sir.
All right, now you got two things going on today. You got your VOP and your new charges. We're taking care of them together, but they're different. Do you understand that?
I do.
All right. As to your new charges, do you understand by this plea arrangement you're pleading no contest?
I do.
And that says to me you believe the state has the evidence to prove your guilt and you're not going to contest that?
Yes, sir.
Do you understand by doing this you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
All right. Now, as to your VOP, do you understand that you're admitting the VOP?
Yes, sir.
And that says, Judge, I violated just the way the affidavit report says it did.
Yes, sir.
And do you understand by doing this you're waiving your right to a hearing where the state would have to prove your violation?
I understand, yes, sir.
All right. And in this case, we're going to combine the sentence in the two different, your new charges and your violation, and you'll be adjudicated guilty. You're doing 3 years of probation on the felony counts. Your misdemeanor counts are credit for time served. The special conditions are you're going to stay in jail until you go to Phoenix House, and you've got to finish Phoenix House and any of the aftercare they direct. Special conditions include all of the substance conditions, evaluations, treatments, testing to confirm those things. And after you get out of Phoenix House, seeking and maintaining employment. Now, my view of that is if you decide after Phoenix House, because they give you a lot of help there and give you direction about how to change your life and to make your life better, if you decide, I want to go to school, I want to get some vocational training, I consider that to be full-time. So if you say, I don't want to make it up, I want to be a welder, whatever it is, and you choose a program, I consider that to be qualifying because the goal of that is to make you better equipped to live a successful life. So if part of that is to get educated or get trained, then I will encourage that and I will authorize you to do that. Does that make sense?
Yes, sir.
As long as it's leading somewhere and you're successfully completing that, because that's the path to help you be as successful when you're done. Okay?
Yes, sir.
You'll have the fees and costs that you'll have to pay, and I'll waive the cost of supervision while you're in Phoenix House. Is that the agreement that you've reached?
Yes, sir.
Now, Mr. McKinney answered all your questions about this plea and how it affects you.
He did.
And are you satisfied with how he's represented you?
Absolutely, yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Thank you.
Thank you.
So,
Hold on just a second.
for the VOP, are you
Thank you, Madam
Be a
Clerk.
re-sentence.
Okay, very good. Thank you, Madam Clerk.
They had Walker necessary to take her.
Judges, Lisa Walker before the court in 3 case numbers, 23 CF 2470, which is a return to the docket on PTI, 24 CF 2108, and 25 CF 212. We have reached an agreement that handles all 3 of those case numbers. The agreement that's been reached is for a plea as charged in all 3 case numbers. An adjudication of guilt, 6 months in the Okaloosa County Jail with credit for all time served. That is concurrent. It's $515 court cost in each of the 3 cases, and a total of $350 cost of defense. May I approach with that agreement and the score sheet, which reflects 41.3 points.
You raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? All right, you can put your hand down. You heard what Mr. McKinney said and you signed the written plea form.
Yes, sir.
How old are you and how far did you go in school?
32, and I made it to 10th grade.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And is what you read what Mr. McKinney just said?
Yes.
Do you understand you plead no contest and waiving your right to a trial by jury?
Yes.
All right, in this case, you'll be adjudicated guilty, sentenced to 6 months in the county jail, credit for time served, all counts and all cases concurrent, and you'll have your fees and costs that were announced that you'll have to pay. How much time do you think you'll need to get all that stuff paid?
About a year, if I could get done.
12 months to pay, and as long as you're paying, if you need a little more time, all you need to do is ask, okay?
Okay.
Now, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, he has.
And are you satisfied with how he's represented
Yes.
you? The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
And Judge, that is with credit for time served?
Credit for all time served. And I guess I should have announced coterminous, right? Because they're separate arrest dates.
Mr. Paul's next.
A concurrent sentence?
Right.
Correct. Judge, this is Mr. Shaquem Hall before the court.
Okay.
These cases were transferred down from Division 6. He has 25 CF 141, 24 CF 2702, and 2 violations of probation, which is the 24 CF 1803 and the 23 CF 2117. In speaking with Mr. Hall at the jail and speaking with the state, we do need to schedule and set depositions in the 24 CF 2702, and I need to get the discovery in the 25 CF 141 case so that we can move on that case as well and set depositions. I've spoken with Mr. Gomez, who's the Assistant State Attorney on these cases now, and I believe that he's going to work on getting me the discovery in the 25 CF 141, and then we will seek to set depositions. So that would necessitate the request for a continuance, and I've discussed that with Mr. Hall.
State?
No objection, Your Honor. I agree with everything Mr. McKinney said.
All right. Matter will be continued then.
If we reach a resolution, obviously I'll seek to put it back before Your Honor.
Absolutely. Thank you very much. Thank you, Mr. Hall.
Judge, I believe that's all my cases. May I be excused for today?
Yes, sir. Good day.
Thank you, Judge.
Sergeant.
Judge, this is Robert Sargent before the court. His parents are present in the courtroom. We have reached a plea agreement that handles all of his case numbers. And Madam Clerk, that does include a 25 CF 934 case.
I'm sorry, say again, 934?
934, yes. That I believe that the state has filed an information on. and we are going to resolve that with lesser included charges in this plea agreement. I just wanted to make sure, since that is a brand-new case number, that we are good on that case. Okay. And I'm going to take my time as I announce this plea agreement because there are a lot of moving pieces to it.
All right.
Mr. Sargent has 24 CF 888, which is a new charge, 24 CF 887, which is a new charge, 22 CF 3041, which is a felony violation of probation, 22 CF 2645, which is a felony violation of probation, and then the new 25 CF 934. The agreement that we have reached with the state is 24 CF 887 would be null prost. That is a 2-count case. It would be null prost in both counts. And 24 CF 888, count 1 would be reduced to a 3rd-degree felony aggravated assault. Madam Clerk, I'll provide the statute number. Count 2 would be dismissed. The violations of probation, Mr. Sargent would admit to the violations of probation in 22 CF 3041 and 22 CF 2645. The new case that just came in is the 25 CF 934. Mr. Sargent would be entering a plea to a lesser included misdemeanor battery. Madam Clerk, that would be 78403 sub 1 sub B. And as I announced the conditions, there are a few moving pieces outside the agreement that I will discuss with the court. But the intention, if we start with the violations of probation, would be to keep the withhold of adjudication in those cases, reinstate the probation, and extend those probations by a period of 13 years. That will leave us with a total amount of 15 years, which is the exposure on the F2s. That is obviously concurrent between everything. And the intention here is that we are, in effect, going to be wiping away the original conditions in those cases and modifying to include the terms that I am about to announce, with $200 in BOP fees and $250 cost of defense. In 24 CF 888, the plea to the lesser included aggravated assault, that is a concurrent 5 years probation with $515 in court costs and a $100 cost of defense. In 25 CF 934, which is the lesser included battery charge, that will be credit for time served, no probation. But there would be court costs of $622 and a $100 cost of defense that we would like to wrap those conditions into the probation. The special conditions on all the probation is going to read that Mr. Sargent must comply with all APD conditions and recommendations, including residential group home placement. We have done an extensive amount of work with APD, and he is move-in ready at a APD behavioral group home tomorrow. That is in Gadsden County. I will not announce the address, but it has been in an extensive process with APD, and he is move-in ready. He must complete a mental health evaluation and comply with any recommended treatment. That is contemplated that would be at the home where they do have behavioral analysts. He may not own or possess any weapons. He may not have contact at all with the individuals from the initial probation, which is Joe Alonzo, Samantha Van Diver, Officer Patrick Mooney, or Joseph Kyers, K-A-Y-E-R. Those are conditions that we're bringing over from the existing probation. He may not have violent contact with his parents who are present in the courtroom. That is Leslie Sargent and Richard Sargent. So he may have contact, but it may not be violent. He may not reside at home with Leslie Sargent or Richard Sargent. So he is not to return home to the family home per this agreement, hence the need for the APD group home. He may not trespass at Rad Junk, which is 217B Miracle Strip Parkway, Southwest Fort Walton Beach, Florida. That is a carryover from the original probation. And he may not trespass at Emerald Coast Martial Arts Academy, which is 726 Beale Parkway, North Fort Walton Beach, Florida, 32547, which is a carryover from the original probation. Given that this is going to be a group home placement with APD, we're asking the court to waive the cost of supervision. And given that this is going to be a residential placement, I know the court will normally ask, how are we going to get from point A to point B? The discussion with APD through extensive discussions would be that Mr. Sargent would be released. We would ask for tomorrow morning at 9 a.m. to his parents, as they are his plenary guardians, and they will drive him to probation to check in with probation in Fort Walton Beach. I believe they need to stop by the sheriff's office because his wallet is currently in evidence and it has some of the cards that APD needs as far as his information. And then he would be taken to the group home.
Would we need a separate order directing the sheriff to release that evidence? I just don't want to set up.
I don't believe we would need one because it would not be of any evidentiary value at that point. And they are his wallet, which includes his identifications.
Okay.
If that becomes an issue, I can provide an order and we can address that separately if it becomes some sort of an issue.
I'd just rather do it as a prophylactic measure. So if you draft one,
Yes, sir.
Yeah, I don't want there to be any stumbling blocks.
Yes, sir. I will do so. Yes, sir.
Like I said, nobody shows up to see me because everything went right. So
Yes, sir.
if we do that order and we can put it in their hands so that when they show up at the sheriff's office, they have it, say release his wallet, I just would
Yes, sir.
feel better about that. That way we'll grease the skids on his journey to
Yes.
Gadsden County.
Yes, sir. We will do so. So I have spent extensive time with Mr. Sargent, and Mr. Sargent has been involved in the transition process with the APD. His parents are present in the courtroom if the court has any questions as to them as to pick up, and obviously they're willing to transport him to probation for transfer of supervision. Do you have any questions at all for me? Okay. May I approach with the plea agreement?
Granted. Now, for state, just reviewing on 25 CF 934, the state's oral motion to transfer that case from Judge Oberleson to this division.
Yes, sir.
Granted. Got that, Madam Clerk? Okay.
Judge, this is going to be a negotiated downward departure. I will work with Mr. Snell. We will need to provide an updated score sheet, given that there's a brand-new charge, and we will present that to Your Honor, but this is a negotiated downward departure.
All right, very good. All right, Mr. Sergeant, raise your right hand, please.
Okay.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, and you can put your hand down. Now, you were here the whole time Mr. McKinney was talking to me and explaining this plea agreement, is that right? And you signed the written plea agreement?
Yes, I know.
Now, have you had adequate time with Mr. McKinney for him to go over all the terms and conditions of this plea agreement with you?
Yes, Your Honor.
And it's what he just announced to me, what you went over with him in this written plea agreement. Now, you've got two different things going on. You have your new charges and you have your violation of probation. You understand that?
Yes, Your Honor.
As to the new charges, do you understand that you're pleading no contest to the new charges?
Yes, Your Honor.
And that says that, to me, that you believe the state has the evidence necessary to convict you, and you're not going to contest that. Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove? Okay? Now, as to your excuse me. As to your violations of probation, do you understand you're admitting your violation? And that says to me, Judge, I violated just the way that affidavit report says I did. And you understand by doing that, you're waiving your right to a hearing where the state would have to prove your violations. All right. Now, with all of that, you're actually getting a single sentence, which are all being combined together. And it provides for a new term of supervision, which would provide for 13 years of probation, which would be a total of 15 years of supervision concurrent. And with all of the special conditions that existed and a modification with the special conditions that Mr. McKinney announced. Most importantly are that you're going to comply with all the provisions for APD, that you're going to enter into and stay at the group home, and do the evaluations and any recommended treatment, and no contact with the folks that were discussed, and no violent contact with your parents. And because of the circumstances, you can't live back at the house. You understand that? All right. Now, has Mr. McKinney answered all your questions about this plea and how it affects you? And are you satisfied with what Mr. McKinney has done for you? All right. Now, this has been a long process to get you into the group home. And that's, you've had all your questions answered about that and how this affects you. Anything that's not been answered for your satisfaction?
I've got one question, Judge Stone. I'm going to a group home, they have weekend visitations. And am I allowed to go back to the house, spend the night on weekend visitations or not?
Not according to this.
Okay, I want to make sure.
Right.
Thank you.
Now, if circumstances change and you talk to your probation officer, they can request a modification. But right now, that would not be permissible under these terms and conditions. My view of that would be is that you're the group home and your treatment goes forward, and the folks providing your treatment recommend that that would be possible, then that would be something you would discuss with Mr. McKinney, and they would take that up with probation. And as long as everybody is on board with that, then that would be possible. But right now, it's not.
Can I spend the night at the hotel if you visit me in Quincy?
No, sir, not at this point in time.
Okay.
That would have to be something that would have to be discussed in the future. Right now, the purpose of this is to sort of be sure that you're in a space where they can take care of your needs and be sure to manage all of those sets of circumstances. That might be premature. Something in the future, we could discuss that. But right now, that's all going to be managed by APD and the group home and by probation. So if that happens in the future, then that's something we could discuss.
One more question on that. Am I allowed to see my parents on visitation at least?
Oh, yes, sir. Yes, sir.
From my birthday?
Yes, sir. No violent contact with your parents is permitted. But right now, residing, which would be the things that you've discussed, spending the night with them, being at the home with them overnight, those would be considered residing with them, and that wouldn't be permitted without a modification. Okay? And the reason we set very clear, bright line rules about that is we don't want the Department of Corrections, who's probation, or one of these officers to have to make a judgment call. There needs to be a very bright line of enforcement. So right now, that would not be permitted. Right? But seeing them and visiting with them is fine, and no violent contact is fine, but the residing with them, which would be spending the night with them and those sorts of things, would not be permitted at this time.
I visit the house and stuff. I can visit the house and spend time at my house.
Start it off like we talked about. You're going to be.
So we're good, Mr.
Yes, sir.
McKinney? Yeah.
Yes, sir.
And so when you get to the group home, they're going to chat with you about all these terms and conditions. And if there's some modification that needs to be made, then you can chat about that. Okay? And I can't answer all of those questions about that. That's something that they'll do after they have a chance to do the evaluations and begin the treatment and look at those kind of things, okay? Right.
And even though it's not written into the agreement, the state would appear to be receptive that if he goes out and does very well, does not violate the probation, and complies with APD and the group home rules, that they may consider an early termination of supervision down the road, given that this is a 15-year probationary sentence. But that's something that Mr. Sargent needs to certainly follow the house rules. Have no violent contact with your folks and anybody else. Okay?
All right. I'll accept the plea. Thank you.
And then the monetaries are laid out on the written plea agreement. You'll be reimposing the monetaries, yes, ma'am. But all the special conditions would be modified, and there would need to be notated on the minutes that he should be released at 9 a.m. tomorrow to his parents, Leslie and Richard Sargent. That way it would give them ample time to get him, meet with probation, and get over to the group home while they have everything ready for him.
Yes, probation. Okay.
Sean Tillman?
Tillman? You're fine, sir.
Judge, this is Mr. Tillman. Mr. Tillman is before the court in two cases, 24 CF 2183 and 24 CF 2443. We have completed the discovery work as far as depositions and things of that nature. That's led us to a discussion with the state that may involve some amount of treatment or reduced charges. I need to get Mr. Tillman evaluated for potential placements for inpatient, including Phoenix House, to see if that is a possibility or not. I've discussed that with Mr. Tillman. So at this position, I would ask for a continuance with the understanding that we've done the work that we need to do to be ready for trial, If we're unable to reach an agreement by the next pretrial, then we would be announcing the case is ready for trial. But I believe I'm pretty confident in discussing this with Mr. Snell that this should resolve.
The state will not object to the continuing trial.
All right, very good. We'll continue the case.
Thank you, Judge.
And once again, if that results, then just move it forward on any one of our dockets for
Yes, sir.
disposition.
Yes, sir.
Next, we have Justin Tipton.
Judge, this is Justin Tipton. He's before the court in a number of case numbers. We have been crunching through depositions for Mr. Tipton, and that's led us, from what we've learned in those depositions and negotiations with the state, I would ask that we come back on docket day, plea or continue. There's some work that I need to do with Mr. Snell on maneuvering some of the charges based on what we learned at the depositions. That may impact the score sheet and may impact where we're at as far as negotiations. So I am hopeful that we can accomplish that. If we say Monday is the status, I don't believe we're ripe for trial at this point.
All right, so leave it on for docket day.
Yes, sir.
Next will be John Wanamaker.
Judge, this is Mr. John Wanamaker before the court in 24 CF 2797. We have been in negotiations with the state for Mr. Wanamaker, including potential Phoenix House resolution for him as well. I have not heard back from Phoenix House on his application. For that basis, I would request a continuance. And if we reach that resolution, I'd like to bring this back before Your Honor. There's also a pending CRD violation that we are trying to get some information on as well to make sure that he would not be hindered for Phoenix House if we were sentenced that way because of the conditional release. So I would request a continuance.
Objections?
No objection, Your Honor.
All right, matter will be continued. Thank you.
Thank you, Judge. Hopefully, we should hear back pretty soon from Phoenix House.
Next, we have Mason Weston.
Judge, this is Mr. Mason Weston before the court in 24 CF 2818. We have reached an agreement for Mr. Weston. The court likely has notes that reflect mental health court. We've chosen to go a different direction with Mr. Weston. And at this time, he would be entering a plea of no contest as charged with conditions of bars to bed Haven House, which is over in Walton County. He is to attend and successfully complete Haven House and any aftercare, 24 hours of community service work, have no alcohol or drugs without prescription, comply with the Department of Children and Families if there's any case plans, reserve over the issue of restitution, $615 in court cost, $150 cost of defense. We would ask the court waive the cost of supervision while at Haven House, and he must maintain gainful employment after he successfully completes Haven House. No trespass at 825 Oak Ridge Road, Fort Walton Beach, 32548. No objections to the score sheet, which reflects 20.3 points. May I approach?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you can put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, sir.
All right, and how old are you?
I'd be 24.
And how much school do you have?
Up to 9th grade.
All right, you able to read and understand the plea form?
Yes, sir.
Did Did you do that before you signed it?
Yes, sir.
And it's what you read, what Mr. McKinney just told me.
Yes, sir.
Do you understand you're pleading no contest?
Yes, sir.
And that says to me you think the state could prove your guilt and you're not going to contest that. Do you also understand by making this plea that you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
And in this case, you'll be adjudicated guilty, be on 3 years of probation with the special condition that you stay in jail until you go to the Haven House, and you have to stay there and successfully complete their program and any aftercare. You've got the substance conditions with treatment and testing to confirm that. You may have to have restitution. That'll be determined possibly later. And you've got to comply with any DCF conditions. You've got your community service hours. And you've got to seek, get employment after you complete Haven House, and you can't go back to the Oak Ridge. And if, as part of seeking employment, you want to get training, like go to VOTEC or something like that, I'm willing to allow you to do that. The goal here is to set you up for success. So if you want training, it doesn't mean you just got to go straight out and get the only job you could find. If you think that that will help you set yourself up for success, then I'm willing to help you do that as part of that, okay? That makes sense? Okay. With that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. McKinney has represented you?
Yes, sir.
All right, I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. All right, thank you very much.
Will the court waive the cost of supervision?
Cost supervision are waived so long as he's in Haven House and until he gets full-time employment.
Thank you, Judge. And to probation, that is going to be bars to bed, and Haven House does have a bed available, so they should be coming to pick him up. Will he report, or they handle the report to Walton?
He probably needs to come see us.
Okay, that, I'll let Haven House.
Haven House needs to arrange that.
Okay, I'll let Haven House arrange that. Like I said.
Next, we have Randy Williams.
And Judge, for Mr. Weston, I don't believe I announced that was with an adjudication of guilt.
Correct.
Judge, this is Mr. Randy Williams before the court, and we have been moving through depositions for Mr. Williams. I'd like to come back on docket day. That has led us to a position that we're negotiating with the state. He has been approved for some treatment options. So I'd like to come back on Monday so I can work with Mr. Snell to see if we can resolve these matters.
Okay, very good. So plea or continue on docket day?
Yes, sir.
All right, very good. See you on docket day. Thank you.
Next will be Antonio Wise, W-I-S-E.
And Judge, this is Mr. Antonio Wise before the court, 25 CF 187, 25 CF 310, and 25 CF 365. I've scheduled depositions with the CAC, which are scheduled for the 2nd of July on all 3 of his case numbers. To complete those depositions, I would request a continuance until the next pretrial date.
There's no objection.
So when are the depots set?
They are scheduled on the 2nd of July.
The 2nd?
Correct. We're not very festive at my house.
All right.
Mine either.
All right, so we'll continue at one cycle, and hopefully that'll put you in a position to better understand where the case is, potentially both of you, and then be in a potential position for disposition.
Yes, Your Honor, the score sheet is very high in this case, and given the amount of counts and the amount of case numbers, I'd like to sit down and go through everything with the state with a fine-tooth comb to see where that puts us after we do those depositions.
Perfect. All right, thank you very much.
Correct. But, like I told you.
Next will be Christopher Warman, W-O-H-R-M-A.
Judge, this is Mr. Christopher Warman. He's approaching in 24 CF 1982 and 25 CF 270. He has family in the gallery that's been here almost all day. I'd like to come back on Monday. We've been reaching out to drug court to see if that's going to be an option. He's done drug court in the past. That may or may not be an option from speaking with Ms. Henderson. So I'm going to ask that we set this on Monday. I should have a clearer picture of whether or not that's going to be an option for us. And at the same time, we're working on other treatment options for Mr. Warman that may line up in time.
Is there a present offer otherwise with that?
Judge, I've discussed treatment options with Mr. Snell. We haven't been provided a black and white offer from the state, but I believe the state would be receptive to a treatment-oriented sentence in this case. We've gone back and forth with whether or not drug court is appropriate, but I'll let Mr. Snell speak.
That's the case, Your Honor. So the defendant scores state probation or state prison time, but we're trying to, we recognize there's a treatment need, and I've been working with the defense on that, but right now, so the answer to the question is sort of, but not really. Has there been a formal offer? We've been trying to work one out to try to find the right outcome for this particular case.
Well, I realize the second case is relatively new, but the first case is a little older. You know, if treatment is where we're focusing, then we need to move as quickly as possible to accomplish that. If drug court's not an appropriate alternative, and I understand there's issues with that just because of the process, but what would we think is a potential alternative? What are we talking about?
Just the guidelines, which is.
No, I mean treatment alternative.
No treatment.
Outside drug court, which I should have an answer by Friday, then we're looking at inpatient residential placements, not excluding Phoenix House and some other residential programs that I've discussed with Mr. Warman and his family.
Okay. And are we waiting for drug court to make that inquiry, or we already?
No, sir.
You've already done that.
We're
Okay.
firing on all barrels here to see what we can get to, as far as what options we can line up if we're going for a treatment-oriented sentence here.
Well, I mean, you know, I read these things, and if the states agree, focusing on treatment, then that, I mean, it seems the facts suggest that. Do you agree, Mr. Snell?
Yes, sir.
Okay, so let's move that direction. If the defendant is asking for that, and of course, you know, we got family here, and we don't always have that.
Yes, sir.
And that supports, that suggests if there's family support, then there's a greater chance of success with treatment. And so, and if the state's agreeable, then we need to really, you know, focus our energy on that, right? And so,
Yes, sir.
A full continuance, you
Judge,
think?
I'd like to come back on Monday to keep hands on it,
Okay.
because just like the court is saying, I'd like to move on it if we can, and I don't want to ask for a full continuance at this point.
All right,
That would be plea or continue on docket day.
okay, all right. And, all right, very good. See you then. And we took care of your Deion Wingate case, right?
Yes, Your Honor, we did. We pled that with Ms. Dudley today.
That's right.